Thanks, Lordship. Lordship, I beg to mention item number 12, 13, 14, 15, Lordship. 12, 13, 14, 15. And for the appellant, Lordship. Lordship, here the leading counsel, Mr. Tayyam Subha, is not keeping well and is recovering from medication. So if Lordship can be gracious enough to when 2 weeks' time slot for the appellant.
2021 matter.
Yes, Lordship. No. Lordship, he's not keeping well, Lordship. He's
Read.
down on by.
Take it up at 2.
I don't have to brief from Mr. Lordship.
2 o'clock.
My sincere apologies, but I don't have to brief, Lordship.
When we'll dismiss for default. Your name is there, you are here.
Yes, Lordship.
I said you didn't argue properly. Don't worry. When you sign the wakalatnama, you have to be responsible. You can't put your wakalatnama just for the sake of it. 2021 matter in Kohima bench. Thank goodness.
Lordship, tomorrow, Lordship.
No, today.
Lordship, in that case, Lordship may be gracious enough to. Can you let me go through the second?
Please, go through this.
Highly obliged.
Lordship, in item number 16, the leading counsel is in bereavement, Lordship.
Item number
16, Lordship.
What happened?
The leading counsel is in bereavement, Lordship. Will it come up after a week?
Lordship, service may be deemed complete. Service upon respondent member complainant. Lordship.
Item number 16, huh? Mr. Kiangami,
Lordship.
the learned PP, submits that pursuant to the order passed by this court, the service have been duly affected upon the complainant.
Lordship.
In that regard, he has submitted a report which is kept on record and marked with the letter X. Yes, Mr. Santiander. You appear for the complainant, none appears here. I'm appointing you the amicus to appear on behalf of the complainant.
Hello.
This court had requested Mr. Santiander, the learned counsel, as to whether he would like to represent the complainant, taking into consideration that the complainant is not represented in the Eastern proceedings. Mr. Santiander, the learned counsel, have expressed his expressed his willingness. Accordingly, this court appoints Mr. Santiander as the amicus curiae to represent the interest of the complainant. A copy of the petition be served upon him by the learned counsel for the petitioner during the course of the day.
Lordship, it is a paper book, so the registry will issue.
A paper book you supply during the course of the day. The registry shall also show the name of Mr. Santiago as the counsel representing, as the amicus curiae representing the respondent member. Two. Let's put this inside, huh? That file.
For motion from the supplementary cost list, item number 20.
Your Lordship. One of this matter pertains to that issue of
not furnishing of grounds of arrest in light of the law laid down in Pankaj Bansal, followed in Kabir, Vian, and even Delhi High Court, then our own High Court also has passed the order. So, Lordship, what has happened in this matter is that on 19th of May,
You are arrested?
I'm arrested, my lord.
Why no bail?
I approached the London Sessions Court by a bail application, affirming my two reasons that I'm not praying for bail on the merits of the case. That is what are the allegation and all, because charge has been framed already, evidence started. So I challenge is that at the time of my arrest, the mandate which is required under section 50 and 58 has not been complied. And on the death ground alone, I should be granted bail because it affects my fundamental rights under Article 22. So I apprise the Honorable Court that these issues has been settled right from Pankaj Bansal, affirmed in Praveen.
Understood, Mr. Burwal, but the question is, why haven't you filed a bail application here?
No, Your Lordship, why I'm apprising is that the Honorable Sessions Court should have, if you see the impugn order which I filed, she has not discussed. The London Sessions Court has not gone into those things. So, prima facie, the Honorable Sessions Court was required to find a finding that yes, the grounds of arrest has been granted or not. And she has not discussed the law, which has been passed by the Honorable Gauhati High Court in Sakib's case. Because the Honorable High Court has said that if a fundamental right is violated and the court see, then and there is a bail should be granted because other proceedings cannot circumvent the fundamental rights. So since the London Sessions Court did not comply, because 227 says what? 227 says that the Honorable High Courts have to exercise the supervisory power before of the London trial courts and all the tribunals so that they don't exceed their jurisdiction. I mean, they are supposed to exercise their jurisdictions. If they're not exercising them.
But why are you not filing a bail application here? My question is specific to that.
Your Lordship, I have prayed in my 227.
No. Why should I interfere with this? Why haven't you filed a bail application? Arrest, challenging an arrest is a different thing. But why should I grant you? You have an application to file bail. There are many judgments out there of the Supreme Court also that when there is a remedy available under law, why you are not approaching this court with that 483 or whatever, 438?
Your Lordship, my Lord will appreciate one thing. That the power of the Sessions Court under Eastwell Act 439 and subsequently this new provision, power of the High Court and the Sessions Court in granting of a bail is coextensive. Now, what I am praying in this matter is that the London trial court was duty bound to, on seeing the records, that I should have been granted bail. But
Mr. Counsel, this does not help your client. Why you are not filing a bail application?
But I have prayed for the interim relief.
No, not in this manner. Here I can only issue a notice. File a bail application, we'll take it up. If there is any grounds of arrest have not been taken into consideration, we'll look into it. Not in this proceedings. Not in this proceedings.
Then in that case, Your Lordship can treat this petition under the bail provision because and the Supreme Court has said that PepsiCo matter.
Go to Supreme Court for that. I'm not going to do that. You want to do one, whatever. You have to file a bail application. File a bail application, I will grant you the bail if there is a violation to this section 50 or 51 of the BNS.
It was old CRPC, my lord.
Then 41.
41, 50 and 58. The Lordship, in that case, my lord, I will move an I in this matter.
No, bail.
Let me be liberty because my lord, I will demonstrate.
You file it. I'm not asking you not to file it. You file it. I'll grant you tomorrow itself. But what you are trying to show is that if a bail is being rejected by the trial court or whoever it is, you are going to file a revision or 227. Instead of that, well, we have also a co-extensive power to grant you the bail, but you're not filing the bail application before this court.
I duly bound to report to that.
The question of arrest, you see, the question of arrest being illegal is another aspect, which I will duly take note of. But this is not going to help your client. Why you not invoking the proper provision?
Because your lordship will appreciate that under 227, why I was inclined to move this matter under 227 was that since the London trial court did not comply with the directions of the Honorable Supreme
But
Court.
that is not going to help you. I can later on pass an order that these courts require to follow all these things. Already the Supreme Court has mandated.
My lord,
So in the bail application also, I can pass that order to the effect that these are the things which the court should have looked into it.
but in that case, your lordship, in that case, keep this matter pending at this point. I will move today itself the bail application. My lord may take up it up because my fundamental rights has been violated.
Very well.
I will take it up.
Don't worry. You are moving a bail application today?
Today, sir. Today, sir.
You have filed it.
My lord, we will just file it, my lord. We will just file it.
You knew about the consequence.
No, I was under the impression that your lordship could have, because in Qatar saying,
Absolutely no.
227.
Now what is happening? Why I am telling you this?
My lord.
Like earlier in the GST proceedings,
My lord.
a person can be arrested
My lord.
if there is a violation.
My lord.
So earlier what was happening, they used to file 226,
My lord.
not to arrest them and all, and the courts were granting them interim relief,
My lord.
not to arrest or declaring their basic idea was to declare the arrest to be illegal and to get an interim. And the interim reliefs were being granted.
My lord.
Now, recently, the Supreme Court came up with that to the effect that all the principles which are there in CRPC would be followed.
My lord.
So, therefore, they are entitled to apply for bail.
My lord.
So, if their grounds of arrest has not been shown, they are therefore required to file an application for bail. And if we are to treat every bail application being rejected out here under 227, when this court has the power under this, then the entire we will look into it. You may very well file 226, 227. We may issue directions, say that you need to look into all these things. But for that purpose, it is not going to solve your client's problem. Your client has to file a bail application. File it.
My lord, I will be doing it today, sir. I will take up.
For admission, item number 1.
Mr. Segi, you always come up with such big files. Huh?
Yeah.
You seem to be the source of environmental degradation. Such big files yesterday also. What is this?
Your lordship, this is an arbitration petition which was filed in the month of February last year. The technical issue came up in this case, your lordship, that the Ministry of Road Transport and Highways have not been made a separate party. And that would not have been necessary in the first place, your lordship, because the Chief Engineer, National Highways, Nagaland, was the representative of both the MOD.
Oh, that matter.
Yes, your lordship.
I remember now.
There was a fallout between the state and the union, your lordship. That
Now, what are you challenging here?
No, nothing is
Say
under
11-6.
challenge, your lordship.
11-6.
Yes, your lordship, 11-6. We want to appoint an arbitrator and it has been going on for more than a year, your lordship.
11-6, you want an appointment of an arbitrator for what dispute?
Your lordship, the dispute regarding the contract work which was to be executed, your lordship, because of the fallout between the state and the union, your lordship, the contractor in this case has incurred huge loss, your lordship.
Very well. But Mr. Angami, you were saying something
Yes.
last occasion, if I remember, you were saying something on that initially when they filed against the chief engineer.
Yes, yes.
So that problem there was a problem and as such it could not have been done. So they withdrew, I suppose.
No, your lordship, thereafter, they filed an IA impeding the Union of India.
Okay,
Your lordship. Yes. Now, your lordship, the status is such that the Union of India was not represented for quite a good number of months, your lordship. Now they are here, your lordship.
Yes, my lord, I'm for January for respondent number 1. My lord, till then we haven't received any instructions.
What?
We haven't received any instructions.
Don't worry. We appoint anybody, then you will have instructions. Where's the 11/6 appointment. When was this CGSE was appointed?
Your Lordship,
When the central government was implemented?
Your Lordship, the central government was implemented by the implement petition, which was allowed on 3/8/2024, Your Lordship,
Okay.
3/8/2024. Then the registered post was delivered on 26/9/2024 as per the registry record, Your Lordship, but they did not appear. So, my lord, dusty service was served on 19th of November 2024. Even then, they did not appear, Your Lordship.
Let's see the arbitration clause.
Your Lordship.
Arbitration clause.
My lord, clause 26.3.
115,
26.
151,
115.
51,
Where is the
151,
page?
150. Page 151.
Page
151.
151.
151. 151. Any dispute or difference, any dispute, difference or controversy of whatsoever nature, however, arises of.
Then the arbitral notice, Your Lordship, is at page 391.
So there is no statutory regulatory authority.
Lordship.
No.
No.
So we have to go as per 26(3).
Lordship, yes. In fact, Your Lordship, there is a provision under Article 26(2) for conciliation. In fact, Your Lordship has given the very good views about this particular appointment of the arbitrator on the last occasion. And I have expressed the same thing to the department. The department also is, of course, taking that views. However, they have, in fact, instructed me with written instruction that provisions of 26(2), which is conciliation, if the parties can go for the conciliation first, because that is what it says, 26(2) says. In case of a failure in the conciliation, the parties can approach the arbitration court. Your Lordship, it is on the same page at 151.
No, he has approached you. You are both of you have keeping quiet. If you are not making any attempt for conciliating,
Lordship.
then what is this? He has written a letter to you, isn't it?
Yes,
12/10/2023.
Yes. Then Your Lordship, thereafter, Your Lordship, after all these things has happened, the Union of India, Your Lordship, has by a letter dated 2nd of May 2024, has cancelled the project.
Very well. And then
Thereafter, there is no correspondence as far as this particular letter is concerned by the petitioners to the department, Your Lordship. I have annexed this letter dated 2nd of May 2024 in my affidavit in opposition, my lord.
Raise your affidavit in opposition.
Your Lordship will find that at page 15.
This is only reclassification. It does not say about termination. Does it say?
Your Lordship, on before the disclassification, Your Lordship, on the third line, to convey the approval of the President of India for desanction of the work.
So that is why,
Yes,
you see, they have desanctioned it. Why? The sanction was earlier granted by the central government.
correct.
Now the central government says that we have declassified it from the national highway.
Correct.
So we are not responsible. It is the state who is now responsible.
Yes, that is what.
That is what is the meaning of it.
Yes. That is what. And the charges, whatever it is, to be paid from the agency charge of the state government. That is what the Union of India is expressing now, Your Lordship.
It also mentioned that any financial implication arising due to any expenditure incurred or claim, if any, made by the
By the
contractor
contractor.
on this work may be booked from the
Agency
agency in
charge.
charge of the state PWD.
Yes.
So you are to pay now.
Lordship, the work has never been commenced in the first place, Your Lordship.
Work has not started.
No, my Lord. The work has never been commenced.
How can they say that before the proceeding has even begun, Your Lordship? There are evidences, and with there are umpteen dozen communications, Your Lordship, by the FAT petition itself. My Lord will fully understand that everything is on record. And that is why we have given them the arbitration notice also, Your
Now,
Lordship.
let us see your arbitration notice.
Yes, Your Lordship.
Page.
My Lord, page 391.
Why you are saying about 3 arbitrators? Does it mention in the contract?
No, Your Lordship.
Then why you are having 3 arbitrators? A single arbitrator can do.
Your Lordship, we are proposing to appoint Justice B.K. Sharma. We have, the petitioner's party have approached Justice B.K. Sharma.
That is a different thing. I'm not
Your
on
Lordship.
that.
My lord,
But why you are having 3 arbitrators?
I have to ask my clients, Your Lordship.
Why?
In any
But
case, Your Lordship,
from the fact, from the materials itself, from your notice itself, you did not do any work because of the fact that they could not give you the ROW
no, Your
for
Lordship,
1032 days.
we were maintaining we have done some work and we were maintaining our stuffs with all our machineries on the spot, Your Lordship.
There is nothing, not a single statement out there.
No, Your Lordship, my lord may kindly come to the termination notice at
I'm
page
not on
311.
that.
Annexure
I'm here.
20, Your Lordship.
292, 392.
311, Your Lordship.
391. On account of the authority's failure to acquire any part of the area required for even after a month from the date of execution of the agreement,
Your
so
Lordship.
and so served an iman of so and so in respect of construction package so and so. There's not a single whisper out here that you have done anything.
Your Lordship, we have actually done, we have invested a lot, Your Lordship. We had all our machineries placed there. We had all our camps set up. We had done some clearance, Your Lordship, awaiting the outcome of the green signal to proceed with the work because the work order was issued. We had already conveyed we had conveyed that we wanted to start the work, and we had every machinery on the spot, Your Lordship, waiting for the issue between the state and the union. And now even the union, they took the step too late. After all the damages have been done, they say that they're washing off their hands. And the state also wants to wash off their hands, Your Lordship. Then at the end, who will meet the losses that has been incurred by the petitioner, Your Lordship? It can be only through the arbitration process.
So whom should we appoint? Arbitrator.
Chief,
If the parties agree, we can go with Justice B.K. Sharma, or if the Honorable Court also.
We
this
have a
Honorable High Court
list
has
of
a list.
arbitrators, okay?
No, Chair, but I can also from the list.
Related for the name. We appoint an arbitration. You whatever decide and fight it out.
Lordship.
I think a local person would have been better. Unnecessary doing the matter, everything out there.
Lordship.
Because Justice Sharma is in Gauhati. And then you can't appoint him like that, no?
Your Lordship.
Nowadays, you have to give him a Mr. Seki, where is the Arbitration Act? You are appearing before this court without a DAC.
It was always in the file, Your Lordship. I do not know how this morning it has been taken out.
Huh?
The Arbitration Act is always part of the file. It appears it has been taken out last night when my juniors were going through the files, Your Lordship. My apologies.
So what is to be done if I have to appoint somebody?
Your Lordship, this Honorable Court has the list of arbitrators. So at the end of the day,
Give him an Arbitration Act. Now, what is the requirement? As per section 12? 5, 12(5).
my lord,
You are going somewhere else.
my lord. No. Yes, yes. Yes, your lordship.
As per section 12, what is required?
No, what is the specific question of your lordship? Because
What do I have to do now? Can I appoint somebody like that? No, I'm
your
asking
lordship.
you. Can I appoint somebody?
Yes, your lordship, my lord will seek the opinion of the person who is to be appointed so that the parties can also serve the notice to the concerned arbitrator, and if he agrees,
Therefore, I'm
Your
asking
lordship.
you to read section 12.
yes, your lordship. May I read then, your lordship?
Please.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, A, such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality, and B, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular, his ability to complete the entire arbitration within a period of 12 months. Explanation 1 and 2, and 2, your lordship. An arbitrator from the time of his appointment and throughout the arbitral proceedings shall without delay disclose to the parties in writing any circumstances referred to in subsection unless they have either been informed of them by him an arbitrator may be challenged only if A, circumstances exist that gives rise to justifiable doubts as to his independence or impartiality, or B, he does not possess the qualification agreed to by the parties.
So, I can't directly appoint.
Yes, your lordship.
I have to first inquire with the judge
My lord,
and ask the judge to give an undertaking affidavit
my lord.
that if he is ready today, if he is willing to take it up, if he is willing to go by schedule 4. Schedule 4 is the fees.
My lord.
As per the schedule 4, he is willing to go. If he is not willing to go, I can impose upon him.
My lord.
So I can't appoint directly,
True, your lordship.
isn't it?
Yes, your lordship.
So first I have to pass an order that there exists a dispute. And because of this dispute, there is a requirement for an appointment of an arbiter.
Yes, your lordship.
So under such circumstances, we will have to therefore ask both the parties. Both of you are agreeable to somebody?
Lordship, as far as that is concerned, I have to take instruction from the department, your lordship. Because the department, as of date, has not proposed any name, your lordship.
Lord, as of now, we are proposing, the petitioner's party is proposing Justice B.K. Sharma. So if they also propose a name, then that would be again on a different circumstance, your lordship.
You have a retired district session judge, Kape Koza, Nagaland. Or in Gauhati, these are not the empanel. Anyway, we can very well ask for them. So, both of you come up on Thursday. Come up with your thing as regards whom do you want to propose.
Lordship.
And then on that day, I will request both the professors
Lordship.
who wants to and choose and request him as to whether he will be ready. Once he expresses his willingness and files an affidavit, because an affidavit is required to be placed, that these are there, he has, because nowadays if you see, schedule 1, schedule 2, I think, the arbitrator also, an arbitrator who has done 2 matters for this company, he cannot take up.
For the same company,
Uh,
Lordship.
So these are various things, but if I appoint it, it becomes irrevocable,
My lord.
because very difficult. So it's a judicial order now, in view of that judgment. What is the judgment?
Your Lordship,
LPP engineer.
I will also consult my clients on whether they want to strictly stick to the arbitrator that they have approached. If that is the case, then they will also have to have their own arbitrator, and then at the end, we may resort to again appointing a neutral
No,
arbitrator.
no, no, I
But
think
both-
one arbitrator there, because you see, otherwise it is too much of expenses.
My lord,
Because
Hello.
you see the schedule 4,
my lord.
for you, there is no problem. You have a lot of money. State of Nagaland has problem.
Correct, Your Honor.
The state has more money, Your Lordship.
Mr. Sethi, you don't know where is schedule 4.
No, Your Lordship, the schedule is not here.
Give it to me. Yes. Give it to me.
No, wait, Your Lordship. It is here. No, this is schedule 14. The fourth schedule, okay.
You are looking somewhere else.
Yes, Your Lordship.
That is why you are not finding him. You see how the payment is to be made.
My lord.
Now, each arbitrator will be paid his fees as per the schedule. Okay.
Lordship.
Now, if you have to, means all the persons will be paid this amount. Now you are claiming 32 crores. If you are having 3, each person will be paid 20 lakhs plus 0.5% of the claim amounting and above so and so with a ceiling of 30 lakhs. So each person will be paid 30 lakhs because your claim is 32 crores. So it comes to 90 lakhs. Okay, 3 arbitrators. If it is a single arbitrator with your amount, it would be 30 plus another 25% of 30 lakhs will be 37 lakhs. Total arbitration. So if you are willing to spend 90 lakhs, you pay 60 lakhs. He will pay.
Your Lordship, I'll consult my clients after this and we'll take up on Thursday. My lord is going to fix it on that date.
Huh?
On Thursday.
Thursday.
Lord,
Come up, both of you. Whom do you want to suggest? I will have to request.
Or if they can sit together. We decide, no, you're doing best.
You consult your clients, I'll consult my clients, and you and I can discuss.
Lordship.
Consult everything.
My lord. Oblige your lordship.
Deeply obliged.
At the request of, taking upon hearing the council's appearing on behalf of the parties. And the parties, this court had asked Mr. So-and-so, the council appearing on behalf of the respondent, as to whether they would be agreeable with the suggestion of the arbitrator as mentioned in the notice. A notice issued by the petitioner. Mr. So-and-so submits that he would take instructions, list the matter on Thursday.
Oblige.
For admission, item number 2.
What is the contempt?
Yes, Lordship.
What is the direction given?
On the submission made by the learned government advocate Lordship, direction was given for regularization of the petitioner within a period of 1 month, Lordship. Now that order was passed on 20th of November 2023. It's already 2025, Lordship. And this year, the state have filed an affidavit saying that the
No, Mr. Imchen, what has
Regularization
happened till
process.
now?
Yes, my lord.
Have you regularized?
Lordship, we are dealing with this regularization of 74 departments in this state. Lordship, we kindly appreciate. Lordship, we kindly appreciate that I have marked to 1 feet. So every year, it has to be in January once, and after 5 months, it has to be in July. So
Mr. Imchen, I think I know what is paragraph 1, Roman 2 of the
Yes, yes.
office memorandum dated 17/3/2015. That I know, but I'm asking you. This order was passed in the year 2023.
correct.
We are in the year 2025. Have you regularized him by now?
Lordship, you see, kindly appreciate the predicament of the state also. Now, department has to send it to the government. Government will have to send it to the BNR department. BNR department from their finance, and then finance to the state cabinet. The process is lengthy. So it's a question of financial implication is also there. And because as I said, we are dealing with 74 departments in this state. All
No,
departments.
Mr. Imchen, you are therefore required to only regularize. There's no added financial implications. Because of the fact that he's already on a regular scale of pay.
Correct, Your Lordship. Lordship,
And you are only creating a supernumerary post against him.
Lordship, please
And the
appreciate-
moment he retires, it ends.
Lordship is correct.
Then-
Lordship is correct. Lordship is correct. But Lordship, please appreciate.
I understand 1 month can go to 6 months. 1 month can even go to 1 year. But can a 1 month go to 2 years? The digit is different.
Lordship, allow me some time.
We'll like to hear the persons responsible in the video out here. Video conferencing. How is it happening? We don't want their presence. They must be busy. Let's see their faces on Thursday. Why it is taking the digit has changed from 1 to 2 years.
Lordship, allow me 3 weeks time. So
No.
that
3 weeks time will be for the purpose of putting them why contempt proceedings is there. Why we should not initiate on proceedings for punishment. That I will give you. Don't worry. That opportunity, I'm going to give it to you. After initiating contempt, then I have to ask them to show cause as to why you should not be punished.
no, Your Lordship.
Let
kindly
me
appreciate-
initiate the contempt proceedings now.
No, Your
Because
Lordship.
as of now, what we have done is only initiating issued notice. Let us
Lordship is 100%
initiate
correct.
contempt proceedings.
Lordship is
It
100%.
cannot go for more than 1 year.
Lordship is 100% correct. But now we are dealing in a block.
Then why did you make a submission to that effect? What stopped you from appearing in the court and telling the court at that point of time, 1 month kindly don't give us? I've understood 1 month can be may go to 6 months. Yes, there is a difficulty. But every 6 months you are required in terms with Roman 1, Roman 2 to look into that. And when there is already an order being passed by the court, it is added responsibility that you should take it up.
Correct.
And when the office memorandum dated 17/3/2015 categorically mentions that it will be done in 2 batches in 1 year, in the month of July, and also in the month of January, the cabinet or the government have thought about it that within these 6 months, this entire process for regularization of a particular person would be completed. This 6 months can go to 1 year, not 2 years.
I
No,
think up your lordship.
we initiate contempt proceedings against them. And what do you have to say about your chief secretary?
Lordship here, again, as I have submitted.
You have no role.
Yeah, I have no role, Your Lordship, because the department, there is a chief engineer's office, will compile it, send it to the government, and the government will thereafter send it to the PNR and then finance and the cabinet. I have no role here, Your Lordship. I have no role here.
So we initiate contempt proceedings against the both of them and ask them to, I'll give you 3 weeks for show cause as to why they should not be punished. Not on that. Don't think that I'm giving you for complying. Once this court initiates contempt, then it has to be brought to a logical conclusion. Means either he has to be punished or do what?
Correct.
But this is not a case by which we are going to, under no circumstances, let these 2 people go away. A contempt of court. Heard Mr. Sentianger, the learned counsel appearing on behalf of the petitioner. Mr. Moaim Chin, Mr. So-and-so appears on behalf of the respondent number 1. And Mr. Moaim Chin appears on behalf of the respondent number 2 and 3. First of all, the present contempt application has been filed. Alleging willful and deliberate non-compliance of the order passed by this court dated 28/11/2023, passed in WPC number 75/2023. First of all, taking into account the this court, taking into account that the contempt proceedings have been initiated, have been filed in respect to the order dated 28/11/2023, this court finds it relevant to reproduce the relevant portion of the order passed by this court. First of all, paragraph number 8, 9, and 10 of the said paragraph of the said order dated 28/11/2023 is reproduced hereunder. From a perusal of the above quoted paragraph, it is seen that the coordinate bench of this court after taking into consideration that the petitioner was appointed on 2/4/1993 and was entitled to be regularized in terms with the OM dated 17/3/2015, taking into consideration that he had already completed 30 years in the scale of pay, have directed the state to complete the process of regularization within 1 month from the date of the said order. This court further finds it very pertinent to take note of that the coordinate bench, while passing the order dated 28/11/2023, had also duly taken note of that the state's stand was that the process also finds it relevant to take note of paragraph 6 of the order dated 28/11/2023, wherein the counsel appearing on behalf of the respondent state had stated before the court that the state had already initiated the process of the regularization of the petitioner and it may take 1 month time to complete the entire process. Paragraph 6 of the said judgment, order dated 28/11/2023, is reproduced herein under. It is therefore seen from the above that the coordinate bench of this court had directed the respondent authorities to complete the regularization within a period of 1 month. The record further reveals that on 15/12/2023, all the respondents herein were served copies of the order. And in spite of that, as the petitioner's services were not regularized, the petitioner had approached this court on 15/4/2024 by filing the instant proceedings. Next. I have heard the learned counsels appearing on behalf of the petitioners, on behalf of the parties. Mr. N. Angami,
Lordship.
appearing on behalf of the respondent number 1, submits that the Chief Secretary has no role in the process of regularization. And a perusal of the office memorandum dated 17/3/2015 would show that the responsibility is on the department.
Lordship, we kindly appreciate my counter. The affidavit filed by the respondent number 2 and 3.
Huh?
The affidavit filed by the respondent number 2 and 3.
Yes.
More particularly, page 6, annexure A.
Where is that office memorandum? Mr. Moinchin, the learned counsel appearing on behalf of the respondent number 2 and 3 submits that there is no intentional or deliberate attempt on the part of the said respondents not to initiate, not to take steps for regularization of the petitioner. And in that regard, he referred to the communication dated 26/9/2024 issued by the respondent number 3 requesting the respondent number 2 as regards the furtherance for the purpose of regularization of the various officials, including the petitioner. First. I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration. First, this court finds it very pertinent at this stage to take note of the office memorandum dated 17/3/2015, and more particularly in respect to clause 1 Roman 2, which is reproduced hereunder. From the perusal of the above quoted clause, it would be seen that in respect of work charge and casual employees in scale pay, and who have completed or will complete 30 years of continuous service after 1/1/2015. Their cases for regularization will be taken up subsequently in 2 batches as on 1st of July and 1st of January every year. The manner in which it is required to be taken up would be in terms with clause 1.1 of the office memorandum dated 17/3/2015. This court further finds it relevant upon a perusal of clause 1 that those persons who have completed 30 years of service, 30 years or more continuous service as on 1/1/2015, after 1/1/2015, on or after 1/1/15, would be regularized by conversion of their post into regular ones personal to them, meaning thereby that there is a requirement of creating a supernumerary post insofar as which is personal to the employee. First, this court further finds it relevant to take note of the affidavit which have been filed by the respondent number
2 and 3, Your Lordship.
respondent number 3, not 2, 3, which shows that a completely contrary picture has been placed before this court to what was placed before the court date bench when the order dated 28/11/2023 was passed. Inasmuch as when the learned court, the bench of this court had passed the order dated 28/11/2023, it was submitted that the petitioner's case was duly considered and it would be completed within a period of 1 month. On the other hand, a perusal of Annexure A shows that it was only on 26/9/2024 steps were being taken for the purpose of regularization of the case of the petitioner. First, it seems that the petitioner, the respondent number 3, it is also relevant to take note of that the respondent number 2, in spite of receipt of notice, have not yet to file an affidavit explaining his stand. First, the manner in which the respondent number 2 and 3 are acting in spite of an order being passed by this court on 28/11/2023 appears that there is a willful and deliberate violation to the orders passed by this court dated 28/11/2023. This court also finds it relevant to observe that a perusal of the office memorandum dated 17/3/2015 does not show any role of the Chief Secretary for the purpose of regularization. Under such circumstances, this court is not inclined to proceed against the respondent number 1, who is the Chief Secretary. But however, as we However, as regards the respondent number 2 and 3, as this court is prima facie of the opinion there is a willful and deliberate violation to the order passed by this court on 28/11/2023. And this violation touches on the majesty of this court. This court, accordingly, initiates contempt proceedings against the respondent number 2 and 3. Full stop. Next. This court fixes this matter again on May 13th, 2025. Full stop. The respondent numbers 2 and 3 herein are given the liberty to file their application, file their affidavits as to why they should not be punished in terms with section 12 of the Contempt of Court Act 1971. This is only for punishment.
Okay. Much.
For admission, item number 3.
Yes, what is this? Criminal case, what is that?
Authorizing the family court order.
Huh?
My lord, I'm praying
What order are you challenging?
a family court order, Dimapur, order dated 27/2/2024.
Page
Page 18, Annex 1, my lord.
1/8.
Yes, 1/8, my lord.
$125. You are the husband?
No, I'm the wife. my lord.
Why are you fighting?
Today, I'm a victim of domestic violence.
What is the order passed?
Order for 7.
Where is the direction? Huh? Which is the order?
Page 18.
Why you are aggrieved?
Page 18 to 33.
What happened?
My lord, the family court, my lord, family court Dimapur have observed that since I've availed the benefits in the proceeding before the GB court, free. Say that the family court cannot intervene. But actually, this is not the case, my lord. My lord, if you may kindly here is Annex 11, page 61 to 63. This is order of the GB customary court.
Maybe Lordship. Lordship, to save the time of this honorable court, Lordship, before going to the merit of the case or observing the judgments passed by the customary or the family court, Lordship, the petitioner here before the honorable court has filed this revision petition under 397, 301 of the CRPC, read with Section 19(4) of the Family Courts Act 1984. Lordship, as per the Family Courts Act 1984, Lordship, Section 19, there's a proviso, Lordship, 19. Hmm. 19(3), Lordship. Lordship has got it, Lordship. Section 3, Section 19, Clause 3. Every appeal under this section shall be preferred within the period of 30 days from the date of the judgment or order of the family court, Lordship.
So the entire maintenance case has been disposed of.
Yes, Lordship.
And is there any case in the family court? Other case?
No, Lordship. No.
Divorce, domestic violence case is pending, my lord. Stated.
Domestic violence case is different. We are not concerned. But is there any case before the family court?
No,
Any
no.
other
The
case?
divorce case is also pending.
How can their maintenance proceedings be there before the family court?
Lordship, they filed under 125 before the family court.
So can the 125 proceedings be decided by the family court? Isn't it to be done by the criminal, the other criminal courts?
Yes, Lordship,
You
but
see, maintenance, if I'm not correct, wrong, maintenance out here, the family court's jurisdiction is it is to that effect, it's nothing to do, it is only where section 26, 25, 26. In application on the evidence record here, civilian criminal, execution of order, judgment, procedure generally. Subject to the other provisions of the provisions of so and so and or other law, and of any other law for the timing of which shall apply to the suits, other than proceedings under remand before the okay, in view of section 8, no? This 125 falls in chapter 9.
Chapter 9, Lordship.
So the family court has exclusive jurisdiction.
Yes, Lordship.
Now, once this section 9, 125. No, kindly come to 19(2) of the Family Courts Act. No appeal shall lie from a decree or order passed by the family court with consent or from any order passed under chapter 9. So therefore, he comes under revision. Answer is here. Ma'am. So your preliminary objection is done. Now argue on merits.
The respondent have argued that as per rule 551, read with rule 64 of the administration of Rules and Justice Police Administration Nagaland, that the maintenance is unmaintainable. Based on that argument, the family court have also dismissed my maintenance case. Since I brief, I put it one.
No, did you earlier agree to it? Did you agree that for once and for all, you don't need any further payment once you have received this amount?
No, actually, my lord, we came to a certain agreement that I'll be given some landed property and 15 lakh. All these were agreed. But before the proceeding, before the GP Customary Court, all these were emitted arbitrarily by the GP Customary Court.
But did you challenge that order of the DB Customary Court?
No, Lordship, that was a good challenge. This was not accepted before any court, Lordship.
Anyways, we'll call for the records.
Lordship.
Upon hearing the learned counsel for the parties, comma, This court is of the opinion that there is a requirement of perusal of the records. So accordingly, the revision application stands admitted. So, list the matter for hearing immediately upon receipt of the records from the learned court of the Principal Judge Family Court, Dimapur, Nagaland.
For admission, item number 4.
May it please lordship.
Yes, Mr. Chair.
My lord,
You don't have any opposition?
yes. No, no opposition, my lord. The petitioner has come before the Supreme Court challenging the order passed by the learned SDO civil Sachit Jubda on 19/2/24. The learned lower court, while deciding the matter, had distinguished the title "My Property" as developed and undeveloped area, and directed and giving the order that undeveloped area should be given as common property for Nipunumia clan. That is the grievance in short, my lord. When the property in dispute is under my possession for more than 100 years. Yes,
What is the order you are challenging?
my lord, lordship, page 66, but the relevant paragraph. Page 66 is the starting. The operative, in lordship wanted to see the operative paragraph, page 70, paragraph 9, 10, 11. These are the operative part, madam.
Now tell me one thing.
Yes, madam.
When did you serve this thing upon this person?
The
Respondent?
Private part. Lord, we have filed an affidavit. We have served the dusty service on 3/3/2025 at 6:30 AM. And his house is bearing house numbers 160E, Sachit Jubda, Kohima. Before the Dobashi, he appeared personally. Even before the SDO, he appeared personally. Now in High Court, he refused to accept the notice.
Now, where is the order? RSA? What is this RSA business?
My lord, not
And
order
the
is,
age-old or constituent villain who submits, they would like to withdraw the instead with the file to.
my lord, order 18/3/2025.
Oh, then I asked you to file an appeal
I have done that because of that, yes.
after 9/12.
Yes.
And
Now-
where is the appellate order?
Order is 18/3 notice. I'm talking about notice. Notice deemed to be completed is the order passed by the Supreme Court 18/3.
No, it's okay. Where is the impugn order?
My lord. Page 66, my lord. NHR 18, page 66. Then lordship, like I've said, the relevant paragraph.
Wait.
Yes, page 66, running page, starting from.
No.
Yes,
9/12/2024, who wants to withdraw? You wanted to withdraw the appeal with liberty
My
to
lord,
file a revision.
yes,
And I asked you to grant you the section 14 limitation,
yes,
isn't it?
yes. So therefore, there's no delay.
Okay, so there is no
No
delay.
delay.
So this is the order.
Yes, ma'am. I have a next one.
All case number 66.
Yes,
The case was taken up as per the directive of the Deputy Commissioner. This is for information.
yes.
Where's the order?
So no, this is the revision, my lord.
Now, where's the order? Which order you are challenging?
My lord, I'm page 66, ma'am. Starting from page 66. The order passed by the learned court of SDO Civil Sachit Jubda, dated 19 February 2024.
Who was the appellant?
Ningu Mezo Nipu.
This side, not
Yes.
you.
Yeah.
You were the respondent in that appeal.
No,
Before-
I was the petitioner, appellant, no, plaintiff before DB.
Before
Because-
DB?
Yes,
Then an appeal was filed.
I was there. I was the appellant.
You were the
Before-
appellant.
Yes. Before DB, I was the plaintiff, because,
No, appellant is okay.
yes,
Your name is Sheikh Hossein.
Tejao Sekose,
So he's the appellant.
yes,
Okay.
I'm for him.
In the regard of
So-
first question, the appellant's family has been in occupation.
Before DB also, he was present. Even before Edge also, he was present, but before the High Court, he refused to come.
So you are aggrieved by that portion
Yes,
about 2.5 acre.
yes. How can it be? Because when I'm the title holder, when the property is under my possession for 100 years, how can the court pass the order that only developed area should be given to me and undeveloped should be given to that community land?
So now this order has been stayed.
Yes, state. Because they couldn't, even before the Tobashi, they couldn't produce any document, the defendant.
You also didn't have any.
No, I have.
No, the court has said that.
No, no, maybe
Paragraph
wrong,
10.
maybe. In fact, SDO or DC himself, Deputy Commissioner, who is the district collector.
No, why
himself-
does paragraph, page 71, paragraph 10.
Yes,
In regard to the second question, any claim of the respondent to the disputed land, it is my determination that since both the parties in this do not possess any documentary.
correct. Now, Lordship will see if we read a 4 pre-page. He has seen, the court has seen all my documents. Thereafter, how can this honorable court come to the conclusion that I have not produced any document? Lordship may just for instance, if Lordship comes to paragraph page 41, where the Deputy Commissioner has given me my ownership land possession certificate. If Lordship comes to page 41,
Page 70, paragraph 8,
yes,
paragraph 8.
yes.
Isn't it?
The appellant, as per the directive of this court, had furnished the following details that out of.
Then I think, this is the very vital aspect, I think we should have to see the records, isn't it?
No,
Because this is, if
Yes,
you have
no,
that,
no.
it is a case of
I
perverse.
have no problem, I have no.
Upon hearing upon hearing Mr. A. Joe, the learned counsel appearing on behalf of the petitioner,
Commissioner.
and upon perusal of the impugned order and further upon perusal of the impugned order dated 19th of February 2024,
Yes,
it is the opinion of this court that there is a requirement of perusal of the records which led to the passing of the order dated 19/2/2024
yes.
by the
SDO civil, SDO civil.
SDO civil Sesu
Sechu Jubza.
bracket Jubza
under Kohima district, my lord.
Assistant to Deputy Commissioner, Kohima.
Yes.
First, the registry is directed to call for the records of poll case number 3/2022 from the court below. First, this court further admits the
misappropriated public money, Lordship.
investigation done.
Yes, Lordship. Charge sheet has been filed, Lordship. And in that charge sheet, CBR report also I have annexed, Lordship. Allegation of 120p, that is criminal conspiracy, and 420 has been framed against me, Lordship. And as well as section 30.
Charges have been framed.
Yes, Lordship.
Then why are we
Lordship,
dealing with this?
not before the trial court, Lordship. CC is yet to be considered, Lordship.
So then, what is
But,
your,
Lordship,
why should we look into it?
no,
You argue that before at the time of consideration of charge, and then again come here, no case made out.
Lordship.
Why you are here?
No, Lordship, there's a difficulty, Lordship. Legal difficulty, Lordship, that is. If my Lord will kindly come to Annex 10, page 304, Lordship.
304.
Yes, it starts from page 304 and ends that same annexure. This is an order passed by the special judge, CBR, Lordship,
Yes.
and ends at page 314, Lordship. Now, Lordship, a discharge petition has been filed, Lordship. And Lordship, paragraph 11,
You got?
paragraph 11, the last paragraph, that is the operative paragraph at page 314, that is the last page of the criminal petition. Otherwise, Lordship, I would have filed for discharge, Lordship, because here
Yeah.
yes, Lordship.
Thus from the above alone, the prayer for discharge of the accused cannot be entertained at this
Yes,
stage.
Lordship.
And the other contention as raised by the defense is not gone into. Even otherwise, with regard to the other contention as raised by the defense, I am not concerned, should be given an opportunity to explain by leading evidence and moreover, accordingly, in view of the above aforesaid, the prayer for discharge of the accused so and so feels and deemed the case trial under so and so. Yes, then. But
No.
this was before preliminary evidence being led by them.
Yes, Lordship. Now, Lordship, I have been sent to the magistrate's court, my case, Lordship. Now, before that court, Lordship, I have made a prayer. If I may be allowed to file a discharge petition, Lordship.
No.
Then, in that case, Lordship,
You are a party to this application.
yes, Lordship.
You asked
It
for
is my,
discharge,
it is my,
this was
application.
rejected.
Yes, it is my application, Lordship.
Then,
Now, Lordship, if the facts, Lordship, are considered at this stage also, there is no case against me, Lordship. Not even a prima facie case,
I'm not
Lordship.
going to look into those.
No, Lordship. There are 6 allegations, Lordship. Those I'm not concerned with those 5 allegations, Lordship. Mine, it deals with any allegation 6, Lordship. That is the construction of the road, Lordship, and footpath. Now, I executed 1,773 or 1,663, something like that, Lordship. Now, after that, Lordship, it was discussed, Lordship, that and decided that only after the completion of the main High Court building. That is a different allegation altogether, Lordship. After that is completed by the principal contractor, that is the main contractor, Lordship, the road encircling that building will be constructed. So that portion was left out, Lordship, to be executed after the completion of the main High Court building, Lordship, because it was necessary, because, Lordship, there was site leveling, Lordship, dumping of construction materials, Lordship, and
Oh,
heavy
this is the High Court.
Yes, Lordship.
Because of you, the High Court has not yet been completed.
No, it is not because of me, Lordship. I'm not the principal contractor, Lordship. In fact, Lordship, because of the delay caused by the principal contractor, this case has also been lodged against me, Lordship. I am a victim of circumstances, Lordship.
To explain it before the trial court.
No, Lordship, because, Lordship, criminal proceedings, it takes time, Lordship.
So therefore, go and explain all these things before and with CC. She says charge has not been framed.
Yes, Lordship.
So go there.
If that liberty is given, Lordship, I'll be very grateful, Lordship. Lordship.
My
Let
lord,
him argue before them.
here, the factual aspect. This honorable court, as well as the party in this case, has to ponder in this case. Now, there was a criminal case against the petitioner as an accused who has been alleged. They file a discharge petition before the special court CBA at Dimapur. The appeal has been rejected, and the matter has been relegated to the magistrate court, who is competent to try the case under IPC. Now, they are saying that the order which was passed by the special court rejecting their discharge petition was illegal. That is their view. But here now, what I'm seeing is, I'm not inclined to any of the parties, but I want to see that here, as per the order of this honorable court, they have been directed and they have been given an opportunity to complete the work as per the order of this honorable court. Now the work seems to have been completed as per the affidavit filed by them. Now here, which the party as well as the court has to look into is the allegation made against section.
No, wait.
Yes, my lord.
This court,
Yes.
Gauhati High Court on administrative side allowed him to work.
Yes.
And the Gauhati High Court, and he has completed some work.
Yes, my lord.
I'm not concerned with those.
All right.
Because that is another,
Yes.
which is, we are not concerned about.
All right.
I'm only concerned as to whether he has a right to make a submission before the authority, before the court, seeking for, at the time of consideration of charge, that no charge is made out against him.
Yes, Lordship.
That's the only
Yes,
question.
yes.
Yes, my lord.
Why should this court look into this aspect? Yeah,
Yes.
he may ask for a discharge. A discharge is a different thing. And you see, the order of the special judge was at this stage.
Yes, Lordship.
See the use of the words.
Yes, my lord.
Paragraph 11, that from the above aforesaid discussion alone, the prayer for discharge of the accused cannot be entertained at this stage.
Yes, my lord. It was a
Now,
prima facie
at the
case.
time of consideration of the charge, at that point of time, no evidence may have been laid at that point of time. When this petition was filed for discharge. Was it filed? Evidence laid? No.
No.
So nothing was there. Now, the prosecution must have laid some evidence. And then only it will go to the stage of consideration of charge. At that point of time, he can very well file an application for discharge and that no case is made out. Because this has been said at this stage, and other contention raised by the defense has not gone into. Even otherwise, with regard to the other contention as raised by the I am of the opposition, that should be given an opportunity to explain by leading evidence. So that means at that point of time, no evidence has been laid.
Very much.
Now, the prosecution have laid evidence.
Not yet, not yet.
Not yet. It's
Not yet.
yet to start, my lord.
Yet to start.
Huh?
Yet to start.
He has to start.
Yes.
So then you will consider, give your due, ask for file an application there, cross-examine.
Then, Lordship, if
You
that.
don't want to appear before the trial court.
No, I very
Taking
much
the
want to
stance.
appear, Lordship. But Lordship, if that liberty is given, Lordship, then I'll be happiest, Lordship, to go and appear before the trial court,
I
Lordship.
understand, Mr.
Yes.
Satendra, that I am the only judge out here who stays till long, but other times, other cases finish off early, 12:31. You
Lordship.
can very well go to the trial court. Go there.
Yes, Lordship.
What is this?
Yes.
And say therefore, I make it very clear that this judgment is only for the purpose of at that point of time stage. And if it is a case where he tomorrow, any evidence is being laid, but you can't delay leading evidence. Is there a stay?
No.
No judicial order of staying the proceeding before the trial court has been passed by.
No. So the proceeding is going on.
Yes,
Is-
Lordship. Yesterday also it was.
And
It
this
was
matter
lifted.
was filed when?
The
Last year, Lordship.
24.
last
Lord.
part of 2024.
20,
And
yes.
because of
We are
filing,
in
In
25.
September, Lordship. In the month of
25.
Yes, Lordship.
So there is no stay. So if there is no stay, then, and what is the stage of the trial?
my lord, because of this petition pending before this honorable high court, the matter cannot be proceeded ahead in that case.
No, Lordship, There's no,
Yes,
and
that's the fact.
no, an opinion was expressed, Lordship, by the magistrate yesterday, Lordship. My learned friend, I believe, because of
I
some difficulty, he
I
was
not
unable to
there.
attend. That it will proceed, Lordship, please.
But here
trial will
insisting
proceed,
at the
evidence will
time of
proceed,
filing of
Lordship.
this petition, they have been insisting on the, before the Honorable Court that it has to be stayed. So that was the,
Because, Lordship, we
Fine.
have,
That is the fact.
at that stage, Lordship, we insisted on several occasions, Lordship, for stay, Lordship. But now, at this stage, Lordship, since it was not, despite no order being passed, Lordship, rejecting the interim prayer, Lordship, and different benches, the said orders were passed that interim will be considered on the next day.
And one
Yes.
thing very.
So interim was
No,
canvassed,
you,
Lordship.
Mr. Sanjay, kindly say. I think we just make it clarify that this order at paragraph 11,
My
which is
lord,
there,
yes,
would not affect your right
my lord,
to file a fresh discharge
yes, my
petition
lord, my
at the
lord,
time of
yes, that is my
consideration of
case, my lord,
charge
my lord,
after the evidence is being laid.
my lord. My lord, if that liberty is given, lordship,
Because
so
this is
that,
only mentioned at this stage.
yes, lordship,
So on this regard, once they give their evidence
lordship,
and before consideration of
my
charge,
lord,
then very well, you can very well do it.
my lord, my, and in order to
Yeah,
avoid
that-
confusion, lordship, if that can be reflected in the order, lordship,
That is what I'm saying.
my lord, my lord,
Okay, I think this can be disposed of
my lord,
by this order.
lordship,
Okay, let me come back 5 minutes.
lordship.
Citation dokumentasi.
Lordship, the remaining portion of the work, Lordship, I have completed. I filed an affidavit to that effect, Lordship. Completion certificate has also been issued by the department.
Who are the persons here? Who are the petitioners here?
They are the contractors, Lordship.
Name?
Ripley Gates and criminal petition 41.
Names?
Tefosatio Rio, he is
Huh?
the first petitioner in criminal petition 43, item 7, Lordship.
What is his name?
Tefosatio Rio. He is the MD, Lordship, the managing director of the firm, Lordship.
These are contractors.
Yes, Lordship.
This Bileli Khamu.
Yes.
No.
No, Lordship, he is a contractor, Lordship, but he has to do with a different allegation. That is the construction of the main building, Lordship. And,
Kindly come to page 306.
and all charges were dropped.
Kindly
against-
come to page 306.
My lord.
They are accused numbers? The petitioners?
Accused number 14, 15, and 16, Lordship.
These are the questions, na?
Yes,
Yes.
14, 15, and 16, Lordship.
Okay. So they have been held to be liable under 120B,
And
420 IPC, read with 13(2) and 13(1)D of the Prevention of Corruption Act.
Yes, Lordship.
Okay, these four.
Yes. However, Lordship, we are not government servants, Lordship. So I believe from 1 to 13, PC Act will be attracted, Lordship. However, for us, so far as we're concerned, Lordship, 120P and 420 IPC only. Since we are not government servants.
Why there are two charge sheets? Why there are two charge sheets?
One is FIR, Lordship,
No,
and one is CBR.
kindly come to 307.
07, Lordship.
307.
Oh, Lordship, this is to do with another allegation. It does not concern us, Lordship.
I'm not asking you. Why there are two charge sheets? I can't write the order just one line. I have to make some reference, na?
Yes, Lordship.
Then
Otherwise, Lordship, with the best of my knowledge, Lordship, this charge sheet number, this is the same charge sheet, Lordship. It's just that in the same charge sheet, different allegations have been discussed, Lordship. So allegation 2 and 3 is a different accused altogether, Lordship. This is to do with construction of retaining walls. That has nothing to do with it.
Blacktop Road and Paka footpath. Okay, so I think there are not two charge sheets. There is one charge sheet
Yes, Lordship.
itself, but this is an additional charge sheet
Supplementary charge.
after further investigation. We are concerned with allegation number 6.
Yes, Lordship. Allegation number 6, yes.
Six.
Allegation F, yes.
Which is in charge sheet number 7.
Lordship, I have only one report with me, Lordship. Annexure 7, Lordship.
Mr. Counsel, kindly come to page 307. You have not read it properly. First, the fifth line from the top.
Yes, Lordship.
Further, separate charge sheet number 7 was submitted in allegation number 6.
Yes, Lordship.
We are concerned with allegation number 6.
Yes, Lordship.
So that is charge sheet
Yes,
number
yes.
7.
Yes, Lordship.
Page 309.
Yes, Lordship. 309. The state still
So
owes
it
me.
is only upon this 309 last paragraph.
Yes, Lordship. The state still owes me more than 1 crore.
Accordingly, in view of the aforesaid, only the contractor so-and-so, so-and-so, and so-and-so
Yes,
are
Lordship.
sent up for trial in respect to allegation number 6, since the government declined to issue prosecution sanction against the accused engineers. But Mr. Santiago,
Yes, Lordship.
you have a problem. Your case which you have made out here
Yes, Lordship.
is certain questions on facts.
Lordship.
The prosecution had not adduced any evidence till then
Lordship.
when this was being done.
Yes.
The stage of CC had not come.
No, Lordship.
Now, if there is no evidence led by the prosecution
Lordship.
against you,
Lordship.
then you can very well pray for discharge
My lord. My lord.
at that stage.
My lord.
But that was not the stage which had reached when you asked for. And you were in fact trying to give a particular your case is that because of these 10 years and all these things have gone by
Lordship.
and nothing remains, nothing can be looked into.
Lordship, there are
There was a
still
delay in
plans,
filing
Lordship.
the FIR, then nothing
Lordship,
can be
Lordship.
looked into. In fact, the state owes you money and all
Lordship,
these things. It's a
Lordship.
question of defense evidence.
Lordship.
But be that as it may, it is for the state to prove
My lord.
beyond reasonable doubt.
Yes.
So that the state has an opportunity to adduce evidence.
Lordship. Lordship.
So there are allegations for which cognizance can be taken, for which cognizance have been taken,
Lordship.
process have been issued.
Lordship.
Now the question is, let the state produce its evidence and then you take up your case for discharge if no case is made out.
My lord. My lord. My lord. Let him produce evidence and then. But Lordship, my only prayer, Lordship, is that I may be
Unless
Given
and
an
until
opportunity,
minority
Lordship.
face the trial, this observation given by this honorable court, it lets they have to face the trial by framing the charge. Later on, he may or the petitioner may or may not.
At that stage of framing of the charge,
Yes.
he can very well argue.
my lord.
Because prior to framing of the charge, you have to adduce evidence.
Very much.
Yes, Lordship.
Then only the charge can be framed
Yes.
on
Lordship.
what counts it is there. It is only a CC being given, it's only an opinion.
Yes.
Lordship.
On the basis of the opinion given by the investigating authority, the matter comes up before the court. The court takes cognizance of it, issues process or no warrants or whatever
Lordship,
may be,
Lordship.
has been done. And after that, it has to be then, you have to adduce evidence at the time. Otherwise, how will the charge be framed?
Lordship.
Once at that time, when the charge is framed, he can very well ask for discharge.
Lordship.
The asking for the discharge at that point of time was, in fact, you are asking the special judge to
Yes.
exercise washing powers.
Yes. That was the fact.
Yes, my lord.
That was
my
the
lord,
fact.
My lord.
Because another aspect will arise
Very
during
much
the
so.
trial.
Yes.
The main problem is that those persons with whom the connivance is being alleged is not a party.
Very much. To that extent also, I believe the state government, they have filed a affidavit. And of the connection, I've also filed an affidavit. Despite of two applications seeking for sanction of this government servant.
That was not given.
Granted.
So as it was not given,
So
can the trial proceed
that's why.
without them is another question,
another
which
question.
will have to be decided on the basis of evidence.
My lord. My lord.
So he can very well pray for discharge at that point of time.
My
This is in fact, this can't be a case of actually a discharge order.
Yes, Lordship. Lordship.
Mr. Santiago was praying out there for quashing.
Yes.
I was not appearing at this stage, Lordship.
Well, appearing or not, but you are now appearing.
Yes, my lord.
You hold the brief for your counsel.
My lord. My lord.
I had to get the idea, so that is why I read it.
My lord.
Leho. Heard Mr. Santiago, the learned counsel, appearing on behalf of the petitioner in the batch of three revision proceedings. And Mr. So-and-so, who appears on behalf of the Central Bureau of Investigation.
Yes, madam.
And Mr.
My lord, I'm
So-and-so
appearing on behalf of Visa Moment. Stay.
appears on. You are a PP?
Yes.
You have to appear as PP? No for BG Momoy or anybody else. You appear for PP? Mr. So-and-so, the learned PP appears on behalf of the state of Nagaland. How can it be? You are a PP. How many PPs are there?
5 PPs now.
There's only one PP who should be there. Others should be APP. How can there be 5 PPs? Is it heard of?
Nagaland is a special state.
Understood. But is it possible?
My lord, we have been designated as a PP to take up the criminal cases in the High Court.
No, you can be an APP. One has to be a PP. Whether your appointment as PP has been approved by the High Court,
No,
then how can you be a
it
PP?
was assigned by the department only, my lord.
No. You can't be a PP
By the
like
state
that.
government, my lord.
For a PP to be appointed, he has to be affirmed by the High Court on the administrative side. That too by a full court. You can't be a PP otherwise. Isn't that the law?
Yes, my lord, there should be an official notification. to
You
that
are
extent.
actually a government advocate. You can't be a PP without the High Court. Even the additional PP also, the High Court in the full court have to approve. Because do you know the reason why a PP is being given? If you see earlier 301 and 302 of the CRPC, makes it very clear the duty of the PP is to assist the court. Therefore, you require the full bench approval, full court's approval. We have to approve that, yes, he will be doing it on the administrative side. Otherwise, you are normally a government advocate.
Yes, my lord. And additional charge has been given by the state government. To take up the
No,
criminal
not like
cases,
that.
my lord.
No. You can be given an additional charge to look into the affairs of the PP, but PP can't be done. Isn't it, Mr. Buragwai?
Hello?
Can a PP be appointed by the state government on its own? No.
No.
It has to have the backing of a full court approval.
In fact, my lord, I was hearing your lordship's conversation with him. I argued this matter before the special court.
Yes, I need see
Yes.
your name in glaring letters.
Our argument was very precise that since the other set of persons are not there, how can you bring the connivance? Because Hexas syndicate, for example, a contractor, the allegation is that I am conspiring with some person. So you have not given sanction to those parties. Now me, how can I conspire with someone myself? That is the thing. That's why the learned trial court referred them, said that PCI won't be there, let it go before this CCM. Against that order, my friend has come. But that is the issue, main issue.
No, you can very well argue
Yeah,
that.
that is the issue.
No, but they can't be PP like this. We have 5. I was shocked. There are 5 PPs.
Yes.
They cannot be a PP because to be a PP, you have to have the High Court's approval. Recently, the PP, we are now having a director of prosecution. Earlier PP Makhon Phukon
Yes,
has now become the director of prosecution. There is another one who was the CBI counsel, Manos Haloi. He has become the assistant director of prosecution. Now, new PP has to be appointed. Now, one Kostop Gogoi, he is now being made a PP. And therefore, the matter has come up before us in the full court. We are to approve. Once we approve, then only the appointment can happen.
Yes.
This is how PP is done. Unless Constitution, CRPC, nothing applies to state of Nagaland. Then he should also not say who is the PP. So and so appears on behalf of the state of Nagaland. All the 3 petitions are taken up together, taking into account that the issue involved is issues involved in issues raised in the 3 petitions are one and the same.
My lord.
For understanding the issues which have been raised, it would be relevant to take note of the facts which led to the filing of the instant proceedings. Next. On the basis of a news article which appeared on 13/9/2017 edition of Morung Express, a PIL bracket Sumoto number 5 of 2017 was undertaken by this court. On the basis of an order dated 2/5/2018, this court directed the Central Bureau of Investigation to conduct a preliminary inquiry into the allegations and submit a report within 3 months to the Registrar General of the court. This court further directed that if the Central Bureau of Investigation was of the view that there are materials to support the allegations, it will take action as per law by registering an FIR, and the state government shall fully cooperate with the investigation. First, on the basis of the state directions passed by this court, the Central Bureau of Investigation made a preliminary inquiry on the basis of a Central Bureau of Investigation, bracket CBI Kohima, on the basis of a preliminary inquiry dated 21/5/2018, registered at CBI, ACB, Gauhati branch, and FIR under for the offences under section 120B, capital B, oblique 420 of the Indian Penal Code, read with section 13 bracket 2 oblique 13 bracket 1 bracket D of the Prevention of Corruption Act 1988, for short the Act of 1988. In the said preliminary inquiry report, in the said FIR, the petitioners in the instant batch of revision petitions were arrayed as were names also featured at serial number 14, 15, and 16. Footstep. The FIR in question was in respect to, primarily was in respect to 6 allegations. Footstep. For the purpose of the present proceedings, the allegations relevant is pertaining to construction of the black-topped road and Pakka footpath paved with checkered tiles from the main highway, bracket NH61, bracket close, dash from Wokha Road to the main building of the High Court.
Lordship, the work order is at page 29.
The said allegation was mentioned in the FIR as allegation number Roman 6. The record further reveals that the CBI initially submitted a charge sheet, which was,
if I may, Lordship, it was recorded as F, Lordship, allegation F.
allegation number 6, no,
F, Lordship, A, B, C, D, E, F.
allegation number F,
Yes, page number 101, my lord.
allegation number F. The CBI initially submitted a charge sheet, which was numbered as charge sheet number 6/2021. The said charge sheet, however, is not relevant for the purpose of the allegation in the instant proceedings. Allegations concerned to the instant proceedings. First, the allegation concerned to the instant proceedings was submitted, concerned to the instant proceedings, was in respect, was submitted, was in reference to another charge sheet being submitted upon further investigation being carried out, which was registered and numbered as charge sheet number 7/2021. First, it is very relevant to take note of that in the charge sheet number 7/2021, the allegation primarily was that after investigation being carried out, it established the commission of an offense punishable under section 120B/420 of the Indian Penal Code, read with section 13(2)/13(1)D of the Act of 1988 by the engineers of the NPWD (RNB) who were arrayed as accused number 3, accused number 4, accused number 5, accused number 7, accused number 8, and accused number 10. So, in respect to the apart from that, the allegations were also made against the petitioners in the instant proceedings who were arrayed as accused number 14, accused number 15, and accused number 16. The state of Nagaland, upon sanction being sought for, did not decline to issue prosecution sanction against the accused engineers. Under such circumstances, the trial proceeded on the basis of only against the accused number, the petitioners herein, who were the accused number 14, accused number 15, and accused number 16. At the stage of cognizance to be taken, the accused number 14, the petitioners herein, appeared before the learned special judge, CBI Dimapur, before whom the charge sheet was filed. It was the case of the petitioners therein that the case of (120B/420) of the Indian Penal Code cannot arise against the petitioner without the trial being proceeded against the accused engineers. It was also the case that without the accused engineers, the offenses under the Prevention of Corruption Act 1988 cannot be made out. In addition to that, there were further submissions being made that no case of involvement of the accused number 4 petitioners arise on account of the fact that there was no money owed by the petitioners to the state of Nagaland. Rather, the state of Nagaland owed money to the petitioners. It was also the case of the petitioners that the commission of the offense which have been alleged was in respect to works carried out 10 years prior to the submission of the charge sheet. And naturally, due to topographical, climate and financial issues, some portion of the road could not have been maintained. First, the learned special judge, CBI Dimapur, upon hearing both the parties, was of the opinion that as the prosecution was yet to adduce any evidence, and the charge was yet evidence, it would not be possible on the part of the learned court at that stage to discharge the petitioners. First, this court finds it very pertinent at this stage to refer to paragraph 11 of the order dated 19/10/2022 by the learned court of the special judge CBI, which has relevance to the present proceedings. Page 314. It has been brought to the attention of the court by the it has been submitted at the bar that as the offense under the Prevention of Corruption Act, under the Act of 1988, was no longer involved, the matter was remitted to the court of which court? Chief Judicial Magistrate Kohima? Dimapur for adjudication. First, and the proceedings thereupon have been registered as CBI case number 1/2024 and pending before the Chief Judicial Magistrate Dimapur. Pursuant thereto, it is seen that the petitioners herein have approached this court seeking quashing of the FIR dated 17/6/2019, semicolon, the CBI report dated 21/7/2021, semicolon, order dated 28/6/2024 passed by the Special Judge CBI Dimapur, to the extent that the petitioners would face trial under sections 420 and 120B of the Penal Code, and all consequential criminal proceedings in connection with CBI case number RC-2 Roman A, capital A, 2019-IMP under section 420 and 120B IPC, so far as the petitioners are concerned, by filing the 3 revision applications.
Lordship, criminal petitions.
3 criminal petitions. So what is your ground now?
Lordship, my only prayer, Lordship, is that at this stage, Lordship, since my Lordship has already expressed.
I have not expressed. First,
Your
you make your
Lordship.
submission. And to
Lordship,
record.
to allow the petitioner, Lordship, to file, that is the second prayer, Lordship, in my petition. Discharge petition before the learned CJM Dimapur Lordship.
Mr. Sankenga, the learned counsel appearing on behalf of the petitioners have submitted the petitioner in the 3 criminal petitions submitted that without the respondents, without the submitted, that in view of the, I would not say anything now on that 420, because there might be 120B may not come, but about 420 allegations,
Lordship.
it is not be proper for me to say
My lord,
anything
my lord.
now. Submitted that the petitioner's limited prayer in the instant proceedings is that upon evidence being led by the prosecution and at the time of consideration of charge,
Lordship.
the petitioners may be permitted to file an application,
Lordship.
respective application seeking the charge.
Lordship.
And the order dated 19/10/2022 passed by the learned court of the special judge CBI should not act as an impediment towards the consideration of
My
such
lord.
application. Mister, what is your submission?
My lord, here, the present revision petition is not maintainable. That's one ground that I'm taking. Then the assertion of the CBA is made out at paragraph number 8 from page 13 onward to this paragraph 14, where
Of which one?
of my objection in affidavit, my lord.
Where?
For criminal petition 41 of 2020,
What is your page? Para?
para 8, page 13.
H. Para 8.
Yes, 8, 8 to 14, where it has been said out that there is no ground for them to discharge from the case. And prima facie evidence against the accused person where they have failed to execute the work as per the specification of the contract and the work order.
Okay, Mr. So-and-so, the learned counsel appearing on behalf of the CBI submitted that no case for interfering with the trial proceedings arises in the by way of the instant proceedings, inasmuch as there is from the materials on record, it would be seen that there that an offense under section 420/120B is made out against the petitioners. In that regard, he had referred to the objection filed by the respondent number 1, and more particularly to the aspects specifically mentioned in page
13 to 18, my lord.
pages in respect to what is this para 8?
Yes, my lord, it is para 8 is concerning with the assignment of
Why you are mentioning more particularly to paragraph 8 to paragraph
14.
14?
Yes.
I've heard the learned counsels appearing on behalf of the petitioner. And where you want to say something? Later on, don't say that I did not give you an opportunity.
My lord,
Being actually a not a PP.
my lord, the state will adopt the submission made by the CBM.
If you say so, do you know the consequences? The moment you say that, you know the consequences. He is insisting that against the accused engineers also there should have been a prosecution sanction. And you have not granted the prosecution sanction. And now, because of you, his case is in turmoil. And now you want to adopt him. The moment you adopt him, it will have far-reaching consequences.
My lord, the main reason is I don't have the brief now. So
The Mr. So-and-so, appearing on behalf of the state of Netherlands, submitted that as the litigation, as the criminal prosecution proceedings is being done at the behest of the CBI, he would not like to make any statement. He's a better. Yes. I've heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. This court finds it very relevant to take note of the order dated 19/10/2022. First, from a perusal of the said order, it reveals that the petitioner at the stage when the cognizance was taken by the trial court, then sought discharge from the said proceedings. The trial court, that is the court of the special judge CBI, as it then was, on the basis of the materials, was prima facie satisfied that there was a case made out, an offense made out for proceeding with the inquiry and trial of the suit, for proceeding with the trial of the suit of the proceeding with the trial. In the opinion of this court, what the petitioners trial, in the opinion of this court, what the petitioner attempted before the learned special judge, that is the trial court, was to invoke the proceedings for quashing of the said of the criminal proceedings, was to ask the learned trial court to quash the proceedings against the petitioners. Which power, in the further opinion of this court, was not reserved before the learned trial court by the Code of Criminal Procedure 1973. This court have also taken note of the order dated 19/10/2022, and more particularly to paragraph number 11, which have already been quoted here in above, wherein the learned trial court had observed that at that particular stage, when evidence was yet to be led by the prosecution, the question of discharge did not arise. First, the learned trial court categorically observed that the stage at which the petitioner sought for discharge had not actually arrived. The learned trial court did not opine that the petitioner subsequently could not have filed applications seeking discharge after the evidence is led by the prosecution. First, considering the above, It is therefore the opinion of this court, considering the above, and taking into account the respective submissions so made out, it is the opinion of this court that after the evidence is being led by the prosecution and at the time of consideration of charge, the petitioner can have liberty, would be at liberty to file appropriate application seeking the charge. And upon such application so filed, the learned trial court that is now the court of the CGM, Dimapur, would be within its powers to decide the said application in accordance with law.
My lord.
So in that view of the matter, this court disposes of the 3 criminal petitions with the following observations and directions. Number 1, on the basis of the materials on record and the facts so asserted, this court is not quashing the FIR, FIR dated CBI report dated criminal charges, not quashing the so and so. Number 2, liberty is given to the petitioner in the 3 criminal petitions to file discharge applications after evidence is led by the prosecution and at the time of consideration of charge. First, number C, upon such application being filed, the learned CGM, Dimapur, shall duly consider the discharge application on the basis of the materials before the court, and pass appropriate orders. The order dated, number C, D, the order dated 19/10/2022 passed by the Special Judge CBI Dimapur shall not come in the way in discharging the said discharge.
Lordship, if that observation 1, if there can be some modification, Lordship, because the trial court may come with an opinion that since this honorable court had arrived at the conclusion that there is a prima facie case, which is why it was not the
No, that will not
42
affect
jurisdiction
this
was not
case.
exercised.
No.
That will not affect.
I
this
never
case.
said that.
Lordship.
You see, yes, a prima facie case is there for proceeding with the trial.
Yes.
But whether a consideration of charge would be made or not, that is a subject matter which he will look into it.
Lordship. Which is why, Lordship, I believe that
Tomorrow, just for example, you challenge an FIR. Okay?
Lordship.
I say that a case is made out, an offense is made out. Would it be mentioned, would it then be the amount that the consideration of charge is not required?
No.
Then don't worry. You have a good case.
Yes, my lord. My only apprehension is that if the CGM reads between the lines, Lordship, I may be
You
in
would
danger.
not read between the lines. You now have a very good CGM now.
Much obliged. Much obliged.
Hello? Somebody there? Can somebody hear me? Sir, the court will sit again or okay.
We have different 8-9 also.
8-9, that will come after over there. So supplementary listed. Item number 1 is. Is that right?
Yeah.
I mean, the affidavit and additional affidavit I just here. Item number 21. I filed yesterday and they informed me just. No, no. Fine, sure, right, because we can correction Gurgena said. Correction Gurgena, I filed yesterday, but they did not. We can Najari cannot. At 1 o'clock. Well, there, additional affidavit will be there. Kita kan mau bilang aku tidak sudah. Lordship, I filed the additional affidavit yesterday Now, at 12 o'clock today, they say that there is little defect. So we have already done that, corrected, and that additional affidavit may be placed before the honorable court.
May I please make it? My lord, in the morning, I moved one application under Article 27. So subsequently, I filed a bill application. Now the registry is saying that they are finding a defect that the affidavit has to be attested by the jail authorities. I am.
He's inside, na?
He's inside. But how, because normally in Gauhati and all, the application, Wakalatnama has to be executed, that is fine. But the affidavit, one has to go before the notary to attest.
No, you do the affidavit through somebody else.
I have done it, but they are putting the file on hold. That we cannot send it to
No, who has done the affidavit?
Affidavit is done by his uncle.
That can be done by the uncle.
Yes, but the registry is not allowing it, not giving us the number. My lord, may kindly call for the files. Because since I'm not contesting on the merits of the matter, just my fundamental rights is a sacrosanct.
You give a mention memo and yes. Next item.
Next item is ours only, my lord.
Which one?
That Pangjung Jamir's matter, that NI matter, your lordship has heard once extensively. That UAP.
Oh, that matter has not finished.
Not yet finished. What happened here, my lord, is that yesterday the matter, cause it was published, the matter is listed today. I have not got the records. So I have already asked my juniors to bring the record. Kindly put the matter tomorrow. Let us go in for hearing.
That's the matter pertaining to NSNK.
Yes, my lord. Exactly. They were also supposed to file an application.
How's your uncle now? How's your uncle? Uncle had some heart attack.
Yes.
That is why the matter got
Yes, yes.
almost 1.5 years.
Subsequently, my father passed away in that.
Your Lordship, well, I have some submissions to make in this matter. I am for NIA in this matter.
Make submissions.
Sir, in this case, I was directed to move an application to include respondent number 2, who was the then CIO of the case. So I'll be filing the application. I've already drafted the application and moved to my headquarters, and it's pending for approval. So I'll be filing the same, so to include the present CIO of the case as respondent number 2.
The concern.
Sir.
The fact is, here he challenging an order being passed.
Sir.
Whereby NSNK had been made a terrorist
Proscribed
organization.
And it was terrorist organization.
Yes.
And second was that the cognizance taken by the learned trial court and the framing of charge are two erroneous way. Like what happened is that they have taken the cognizance before the trial court has taken the cognizance. I was against me also cognizance was taken. But in the meantime, I filed the matter before this honorable court, stay was granted. So what the learned trial court did was that trial court framed charge against the other accused persons and fixed the date for prosecution evidence and kept my matter pending. So now what happened is that once you have already framed the charges and you have fixed the prosecution evidence, the trial commenced because there was no separation of trial. So entire order is non-nesting law. That is what the two arguments were there. And your lordship was fair.
No, that is what I wanted last time to regularize. We don't need that application. That application is
Please,
not
Your
necessary. Unless these are not.
I was directed actually, sir. That's why.
Not necessary. We'll have it tomorrow, this matter.
Actually, I am, sir. One more submission, sir. I am having trial matters at Dimapur court, so I'll be attending those matters today, tomorrow, sir.
See, this court had already framed out its mind before your predecessor came over, as regards the order to be passed. That order was supposed to be passed at 2 o'clock on that date. That date, however, on account of certain personal difficulties,
Yes, madam.
in
the midst of hearing,
there are two aspects which I remember. One was a challenge to this NSCNK. I am going to negative. The second is as regards the other one, this seems to be regularized by setting aside this order and thereby proceeding with the trial. Okay? So there might requirement of framing of fresh issues, fresh charges if necessary.
Without being influenced by the earlier charge order. Without being.
So that is the order which this court is going to pass. Tomorrow, if you appear, don't appear, that is your.
Can we have this in the next week, Your Lordship? In
What?
the next week, Your Lordship, in the next week, if possible.
Mr. Counsel, I'm not adjourning the matter beyond tomorrow and you are asking for the next week. This is a good audacity. We'll have it tomorrow.
Please, Your
At
Lordship.
3, my lord. At 3 p.m. At 3 p.m.
Why 3 p.m.?
Because your lordship, there is a division bench also, my lord. I have to appear in one matter in VC. That's why if it at 3 p.m., my lord.
At 3 p.m. after division. Let us see. I have some other matters.
My lord,
I'll fix some other matters tomorrow.
I have to appear in one.
Okay, we'll have it day after then.
Yeah.
Yeah.
Wow.
Okay, give me the next item.
For admission from the supplementary course list, item number 21.
What do you say?
Lordship, I have filed my additional affidavit.
Okay, not you.
No, Your Lordship, since there is a lapses, Your Lordship, so let there be re-inquiry, Lordship. Inquiry of the matter.
There has to be a fresh inquiry.
Yes,
That
yes.
is one thing. That is not the problem.
As
How do you take care of this? It will now have, it will amount to his reinstatement.
yes, Your Lordship, so Your Lordship, let it be amount, let it be subject to that, and let the.
No. The reinstatement will happen automatically now. You have to go for that because you see, 9(1) categorically says that
Yes, Your
without an inquiry, you cannot.
Yes, Your
Now,
Lordship.
if I hold that the inquiry is bad, all orders consequential becomes bad.
Yes, Your Lordship.
Okay, so therefore there is no termination. So it has automatically to be reinstated. Okay. Now the question is, I give you the liberty to go ahead with a fresh inquiry. You go ahead. So you go ahead with a fresh inquiry. The only thing is out here is that what will happen means he will be again reinstated back. Now, what about the back wages?
Your
No
Lordship,
pay, no
when
work.
there is no work, no pay, Your Lordship.
But
that is-
wasn't it yours because of your fault?
Exactly.
She
There
had
might-
suffered.
Yes, Your Lordship, there's some lapses, however, Your Lordship, there's also a commission of an action, Your Lordship, so taking into that consideration, Your Lordship.
Why don't you ask your person? I'm not saying it. This order will go for a reinstatement. Why don't you ask your person to be liberal
Yes, Your Lordship,
and give a smaller punishment?
yes, Your Lordship,
Then I don't go into those
please. Your
and she will take it, the smaller punishment.
Yes,
and
Your
be
Lordship.
reinstated.
He, Lordship.
Oh, yeah. But as you are appearing, I'm putting that shame.
Your Lordship, that,
Think about it. Instead of termination, this is too severe for a slap. Yes.
Yes,
And
Exactly.
these things, and you see, he had admitted to the guilty,
Yes.
whatever may be. Maybe it must have been said, okay, you accept the guilty, we'll take it up.
yes, Your Lordship.
We won't do. But why this punishment is severe? I can't touch normally on the punishment, on the severity of the punishment. But if this procedure goes, everything goes,
That's true, that's true.
take your action and what is the punishment you are proposing?
Your Lordship, I will
It
apprise.
should
that.
be within 7(1) to 7(3).
Yes, Your
Or
Lordship.
at best 7(4). 7(4) is what? We got that act. What is 7(4)? 7(1), 2 and 3 is minor. Minor.
Yes.
The 7(1) is censure. 7(2) is what?
7(2) is Lordship, conduct rules or the discipline and appeal rules.
Discipline and appeal rules.
This,
Come to 7.
one is censure and withholding of promotion, minor penalties.
Number 2 and number 3.
Number 3 is recovery from his pay of the whole or part of any pecuniary loss caused
So
by negligence.
3
It
does
doesn't
not come in.
Yeah,
Then, no, come to number 4.
Then withholding of increment of base.
Now, the thing is, withholding of increment is a major penalty.
Yes,
You have to go for that. If you go for that, I think, madam, you may not have an objection.
Lordship, I'll leave it to my
No,
lordship.
don't leave it to me.
discretion.
Come up with that. We'll have it on Thursday.
Lordship.
Get your instruction on that.
Lordship, yeah.
Otherwise, I set aside. Once I set aside, it becomes a big issue. Means tomorrow it will come of back wages
Exactly.
because illegally.
Lordship, that has been discussed, Your Lordship.
Huh?
However, Your Lordship, I will get a concrete in written because Your Lordship, since that we have discussed in light to what my Lordship has suggested, we have dive into that also, Your Lordship, that with having that minimal, yeah, 274, maybe we can, if the court allows, maybe that.
Because
will be
you are,
done.
you see,
No
if you,
back
if
wages,
you
Your
don't
Lordship.
get no pay, no work,
Yes, Your Lordship.
for no work,
Yes,
that
Your
is enough a punishment for
Yes,
5
Your
years.
Lordship.
So instead of that, you will
Yes, Your
reinstate only on the ground that there is no pay or no work.
Yes.
Come up with that instruction.
Okay, Your Lordship.
I think you will be happy with that.
Lordship.
It's
It's just that
Based
lordship,
on the increment, Your Lordship, the 7-4, Your Lordship.
No 7-4 business. You have already punished him, no pay, no work.
yes.
The moment you come into the question of increment, then the question will come in that you have to
Yes, Your
pay.
Lordship.
Don't you think that?
Yes.
If you pay, now you are going for no pay, no work for these 5
Yes,
years.
Your Lordship.
So that is enough of thing which you have got.
And you will be reinstated, Your Lordship.
He'll be only reinstated to his old job.
Okay.
Okay?
Okay.
Lordship.
I think that is a better option.
Okay.
Come up with an instruction, written
Okay,
instruction.
Instruction.
That convert it from so and so. I'll just pass that order
Okay,
and giving you the handle.
Okay, please.
Exactly. Lordship.
This court heard the learned counsels appearing on behalf of the parties. And more particularly in the light of the additional affidavit filed by the counsel, filed by the petitioner. Taking into consideration the misconduct, the alleged misconduct on the basis of which the punishment have been imposed of termination. This court heard Ms. Livika on the proportionality of the said punishment. First, the counsel submitted that she would like to take up the matter with the respondents and as to whether the said respondents would be ready to reinstate the petitioner without back wages. More particularly, as to whether the respondents would like to reinstate the petitioner without back wages. First, she therefore submits that the matter be again taken up on Thursday. First, list the matter again on Thursday. Huh?
Oh, bless you.
This is the handle I'm giving you.
Yes, Your Lordship, thing is one.
For admission from the supplementary course list, item number 22.
Mr. Sentyanger, I am going to put one line out there that the observations made in the above order shall not influence the output.
My lord.
That, okay?
Good job.
Yes.
Lucky guy.
No, I thought about it.
Yes.
This matter, yesterday, Your Lordship was asking us to whether the under 31, the decision of the KVC will survive in view of the fact that the appellate court has not specifically or more expressly set aside or set aside the order. Now, in this regard, I have a decision of the division bench. At paragraph 8. Paragraph 8. Paragraph 8.
8.
Yes.
So where does the question arises for filing a suit?
for filing a plaint. Since the proceeding will start afresh,
How do you file a suit?
under 31.
If we go by the judgment, the concept of it being converted into a suit is foreign. The entire proceedings before the civil judge is bad. Absolutely. How do you convert these proceedings into a suit? Unless somehow or the other, section 30, rule 31 has been given legislatively. You see, the question problem arises out here. By way of a judgment and power cannot be conferred upon anybody. You can't confer. Though many courts does it, that's a different thing. I will be the last person. Power cannot be conferred. Power has to be on the basis of a legislation. The legislation does not give a power. If you see the facts of this case, this is very interesting.
Yes.
A person files an application. Whatever may be, it was referred to the Dobashi court. The Dobashi court dismisses his application.
Yes.
Thereupon, when the matter was appealed by the person who filed that application, the court decided to go ahead with the de novo trial.
Yes.
The DC.
Yes.
One has to also understand this is an 87 judgment, where the 2004 full bench did not come. Separation of the judiciary with the legislature is not there. Now 31 says the deputy commissioner or anybody else which is being mentioned either shall just decide on the basis of principle of justice and confirm it, confirm the decision of the Dobashi court, or he may go for a de novo trial. De novo trial, therefore, in this case, if you see, there was a direction for filing of fresh written statements. No plaint.
I believe the plaint was also filed.
No. Only see, paragraph 7, the last line. Okay.
Yes.
So therefore, giving both the parties opportunity. Now, de novo is being taken in paragraph number 8 is being taken from Black's Law Dictionary that it is the original, that they will do afresh the entire thing. The entire thing will be done afresh. So there is a decision being taken that there is no existence of that thing. But how on earth that his case can be dismissed for default? It is therefore when the court takes up the role that it will go for a de novo trial, it has to do it. It is the responsibility of the court to do it.
In the revision petition, the court did it. The court did it for de novo. Of course, in this Nadankava's case, it was transferred to the court below.
How is it transferred?
Well, I'm not arguing on that respect.
No, you have to argue on that. How can it be transferred to that court? Because that is your basis of your case. Entire case, your basis is that his case, this matter was transferred to some judge out there, and that judge, he did not, he filed a plaint.
Logic.
And the plaint was dismissed for default. Without a restoration, nothing remains. So therefore you say when it is a de novo trial being gone into, this has happened. So it is a fresh decision to be taken.
Yes.
But whether the court has passed any order to the effect of de novo way one should go, or is it the parties have agreed? Let us see that.
Yes, the order. Yeah, it is the code. Page 22.
Kindly see here, page 24. This is actually the order. Learned counsel R. and so present, heard both the parties at length on their plaint, and I observed that the instant case be tried de novo in the interest of both the parties. Therefore, parties are to submit issues. So issues is being done when the court decides it will go for de novo. And the plaint is filed before that. How is it possible?
No, prior to this, there was no plaint. I think this reference to plaint by the.
Kindly come to this order of 2005, na? Another order. Yes, this order. Date of the proceeding, this one. Before the assistant to the deceased, so and so, page 21. Received C appeal filed through learned counsel so and so against so and so's decision dated passed in so and so. Appellant to take steps to serve summon. The said order is hereby stayed till further orders to the effect. Learned counsel for the appellant also so and so for the respondent fixed for WS. Now you see. See this, page 21.
Yes.
Fixed for WS.
Yes.
Who is to file the WS?
Respondent.
Okay. Then what happens? Heard so and so, heard both the parties at length on their plaint, and I observed that the instant case can be. Plaint is where? Where's the plaint file?
No, actually,
where's the order sheet?
there was no plaint file. It was the appeal memo.
Written statement filed by the defendant. Who is defendant? What is your name? Not your lawyer's name, your client's name. Soboni.
No, Lordship. That's the petition.
Who is Soboni?
The petition. The petition.
He's filed a written statement. Then there's no plain file. For declaration. You filed the suit. Permanent injunction.
Yes, that was titled suit.
To the court that the matter be sent for de novo due to lack of sufficient evidence. The king of the counsel for the present defendants. Pray to the court that the matter be sent down for de novo due to remand. Accordingly, the learned court passed necessary order to that effect without hearing the appeal. Hence, it has become necessary to file the suit. Suit filed, there's no order sheet, nothing more. I haven't seen the strangest. This is the entire record, what it means. Mr. Joe appears on 7/7/2008. And who has dismissed this?
The civil judge.
The
civil judge.
Huh?
Civil judge.
This is by the civil judge.
Yes.
There's no heading, nothing. Is this the records? See? And what are the orders you have referred to?
Those are the CTCs which I've obtained from the record.
Huh?
The CTCs which I've obtained
Where do you get these orders?
from the through CTC, from the court only.
Where? There's no order there, here in this file. In Nagaland, Limitation Act applies?
Yes.
Who is in occupation of the land?
Lordship, all along, I was in possession, Lordship.
You are still in possession?
I was enjoying the possession all along, until
Who
2000.
is in possession of the land now?
We are now the plaintiff, the petitioner.
When?
Since 2020, Lordship. Since 2020,
20. They are in possession.
they are in possession. They have taken forceful possession of my property, Lordship.
But why did you file the suit in 2008 calling for recovery of khas possession in favor of the plaintiff?
Lordship, I was not in the council in the earlier.
Counsel, no, this person has signed it. The plaintiff is also there. Oh, goodness.
Lordship, it appears from the record that the council himself has sought permission from the court to file the plaint.
Huh?
The party themselves, the respondent has sought permission from the court. It appears from the record that to file a plaint. Initially, Lordship, I have not filed.
Now, who dismissed? This dismissal is by the
Civil judge. Lordship.
Huh?
Civil judge.
Civil judge. Now, how did you file? You filed it before the district judge, DC.
Lordship.
You filed it before the DC, assistant to the Deputy Commissioner Nagaland.
Yes, but this will be assistant to DC judicial.
What do you mean?
Equivalent to the civil judge junior division. And that was how the civil judge took up the matter.
Written statement filed in 2008. The entire process has been. And there's only 2 orders. Is it possible? Or he has not given the entire records? See the entire records? Both of you look into it. Is it possible such records? Possible. Hey, give me the 1937 rules.
Your Lordship,
37 rules. It's a blue book, no?
Your Lordship, the question as to whether I filed the blue S or not initially, when the appellant.
You have filed the
filed
WS, no?
I
Fixed
filed the
consuls
WS.
11/10/2004 for WS.
Yes, Lordship.
Then where's the order? Next order, why after 8 months, 12 months? This order has come at page 22. What happened in between?
Lordship, this file is titled suit. Now the other one is civil appeal. So I believe there may be 2 files. I believe there may be 2 files because the first proceeding was the appellate proceeding, civil appeal. So those orders appear to be missing. So there may be 2 files.
Rules of administration of justice. Show him the blue book. Yes, this. An appeal shall lie from the decision of so and so to the tribal court wherever constituted. Now there is no tribal court.
No.
To the deputy commissioner or his assistant, a record shall be made of the matter in dispute and the decision of the village authorities. If necessary, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as on its own. If the court sees reason to doubt the decision, it will try the decision de novo or refer to the panchayat as above.
Lordship, may also like to peruse Rule 24. Rule 24. Page 31 of the Blue Book.
Yes. What is this?
Every civil suit or action.
Mozadas Gamburas.
No. Rule 24. That will be the new rule. Page 31.
Page
31.
31.
31.
Yes. This rule has come into act.
Yes, since 1980.
All the new rules have come in after the 84 amendment?
Yes,
No.
not all, but this is in force.
Every civil suit or action under this chapter shall be presented in the court by filing a plaint which shall contain the following: the name of the court and so on. Whether the court, and when was this brought in?
The 1984 amendment, that will be the third amendment actually.
Huh?
Third amendment, 1984. Third amendment, yes.
No, Mr. Counsel, whatever may be, there is a decision by the court doubting the decision of the Gambula.
Lordship.
And on the basis thereof, have gone for de novo.
Lordship.
Now, prior to that, and thereupon, you acted on that decision.
Lordship.
And after acting on the decision, you filed a plaint. And your plaint then upon got dismissed for default when no parties appeared.
Lordship.
Okay. That happened in 2011. Now, in 2011, whether the CPC applied?
Now.
No, 2011 Nagaland CPC?
In spirit. In spirit.
Huh?
In spirit.
Then how can the court dismiss for default?
Applicability of the spirit maybe.
Huh?
Applicability of the CPC spirit.
No, you can't dismiss for default unless the power is there. Because there are various features. Just for example, Order 9 Rule 2 says that you have to take summons.
Yes.
Order 9 Rule 3 says you have to take summons and then the other side has to appear.
Yes.
Order 9 Rule 3 says when both the parties don't appear, the court will dismiss. Order 9 Rule 4 says that if both the parties, then in that regard, he is not barred to bring a fresh suit within the period of limitation.
Yes.
Whereas Order 9 Rule 6 says that if on the date on which the suit is fixed for return of summons and the defendant does not appear, then in that court, the court will proceed ex parte. Or if the defendant appears, files a written statement or whatever may be, and on a particular date, if the person does not appear, court will proceed ex parte against him. Now, Order 9 Rule 7 categorically says that a person can very well show a good cause, the defendant, on the ground why he could not appear, then the court will put the clock back to the date on which he did not appear. This is Order 9 Rule 7. Now, Order 9 Rule 8 says when the defendant appears and the plaintiff does not appear, then the suit, unless the defendant accepts certain claims, is required to be dismissed. Order 9, Rule 9 says it will be required for the purpose of restoring, you have to file a restoration application. Order 9, Rule 9 says you have to restore an application. Now, when you if you don't restore, the second suit is barred. Okay. Now, if you see Order 9, Rule 9 and read it with Section 12 of the CPC, it will show that this bar, because of that, Section 12 also bars a fresh suit. Okay. Now, he can very well bring a suit taking into account the order which has been passed where both the parties did not appear. That is one. But there has to be a power given.
Nevertheless, the respondent has not challenged it.
Power has to be given somewhere. Where's the power to dismiss for default if the CPC is not applicable? I give you a very good example in this respect. Now see, in execution proceeding is under Order 21. Okay? When it is an execution proceeding is under Order 21, because of Section 141 of the CPC, all the other provisions of the code does not apply to execution proceedings. So, for the execution proceedings, this is not applicable. Now, what happens? Execution proceedings initially did not have the provision of dismiss for default. So, the Law Commission in 1964 submitted a recommendation to do so. It was not done. There were a lot of problems. And what the people were doing, the litigants, they were coming under 151 because there is no provision. Then came the 1973 Law Commission. It again reiterated you need to do it. Therefore, the next, you find an amendment by being inserted by Section 73 of the 1976 amendment, whereby Order 21, Rule 105 and 106 have been included. Because without that power, you cannot dismiss for default. You are bound to decide.
Lordship, I concede that. I concede that the plaintiff must have pursued the case.
No,
However,
the
as your
only
lordship
way
has
out,
rightly
Mr.
pointed
Counsel,
out-
only way out,
Yes.
this counsel is, I have now to restore the suit.
Lordship.
Restoration of the suit has to be done by me here in this case. And by restoring, because this was an order which could not have been passed by the trial court. CPC did not apply.
Lordship. Yes, that's a fact. CPC did not
So it
apply.
has to be restored. So let the trial court decide now. Who decides? ADC or court? Because if I don't, the problem may apply. That is why I asked you about the Limitation Act. I would have asked him to file a suit. If the limitation apply and you are in possession, as because he is asking for recovery of khas possession in the year 2008, 65 will, Article 65 will be your boon adverse. Isn't it?
That is the impediment.
So the only way out is, because the litigation has to have something.
It has to have something.
The order was passed wrongly. The CPC did not apply. But as I am going to pass an order in that regard, whereby this may have an impact, and taking into account the promise I made to your father, the senior Iralu, I will have the matter on Thursday.
Then would your lordship be relegating the parties back to the civil court?
Huh?
Would your lordship be relegating the parties back to the civil court?
No, the matter will go to the civil court. The civil court, no, to that court. It was before the ADC to judicial, na?
But
it was before the ADC
Yes,
judicial.
ADC
Now,
judicial.
ADC
Now-
judicial, what they have done, this is another very interesting thing your Nagaland government has done. The ADC judicial has been given a name of Civil Judge Junior Division. But without a power being conferred by any legislation. Because if I don't restore his case there, then the problem which will apply is that will be a complete injustice to him.
Yes.
You adjudicate, you fight out, whatever may be, you fight out.
Otherwise, Lordship, my contention is that the GB judgment still stands, considering that it has never been quashed.
No, the
Yes.
problem will arises because of you, and I can't touch it in view of this paragraph 8. If he doubts the decision,
Lordship.
then he will go for a de novo trial. Now, if he goes, that means he has already doubted. And you accepted the doubt by filing a plaint. That is the problem, Mr. Counsel.
I concede, Lordship.
I would have, otherwise, I was in your favor. But the moment this judgment in paragraph 8 is a bit dangerous for you. If I was sitting in the division bench, I would have thought something and made a reference. But I'm sitting single, I can't.
Lordship, I have some authorities in my support also.
Huh?
In support of my case also, I have some authorities.
Show me. Then I can say that this judgment would not apply.
I think the principle of functus officio will also is in line with the division bench judgment. The principle of functus officio.
Huh?
Yes, Lord.
Yes. What is this?
Lordship, this pertains to where the proceeding of the stay is granted and ultimately being dismissed. Then the interim along with the interim goes along with the main proceeding, Lordship. Lordship, may kindly see para 24. Married, Lordship.
This is not going to help you out. Very difficult. So this is on a stay what have been granted, it merges and all these things.
Yes.
But the fact remains that you have by your own conduct accepted that and filed the plaint.
Lordship, that's the peculiar situation I was the claim. I have already filed a claim there. Otherwise,
Problem arises there.
otherwise, in normal circumstances, Lordship, when a case is dismissed, then the interim will stand vacated. Then in that situation, the GB's court judgment is revived.
But here the appeal was allowed.
This is not a case where the matter was decided on merit.
Normally, what is the principle? When there is an order passed
Lordship.
by some authority, when an appeal is being filed, the appellate order, the appeal has to be decided by which the order has to be set aside or confirmed.
Yes.
Either.
Yes.
That is the normal practice.
Lordship.
But Rule 31 gives a different flavor. Rule 31 says that if there is a doubt in the decision, the court is required, the authority shall go for a de novo. De novo means the earlier thing, whichever has happened, no longer exists. That is why the word de novo has been used.
However, Your Lordship, this very bench in one of the order has stated that, has held that in such situation, whether when the de novo is being allowed by the High Court, in such situation, whether the lower court's decision can be questioned, set aside, or it can only be stayed. And this court has held that it can only be stayed. It cannot be questioned, set aside. Relevant portion is in para 12 and para 14, that's it. Para 12 and para 16. Sorry. Sixteen is the operative part. Also, to find the submission of the petitioner counsel, who is also the petitioner counsel here in para 7. And the
Para 7.
para 7,
Ah.
his submission, yes. In para 7, and this may be relevant to check. This is the submission made by the petitioner.
Hello, then in that regard, if I may submit this, while we were submitting it for your lordship, this division bench decision may not have been placed.
Yeah, don't
At this
worry.
point.
I'll take care of the division bench.
May I also
Ask,
make one?
ask your senior to appear.
Very well.
Place the matter on Thursday at 2 p.m. At 10:30 a.m. At the first item of the first item.
Right, Lord.
Other matters we have to come, they're saying, they'll be sending it. The registry is sending it.
Well, I'll take it. Don't worry.
Yes, Lord.
For admission from the supplementary cost list, item number 23.
Lordship, yes. Mr. Santiangal, the learned counsel appearing on behalf of the petitioner submits that taking into account that the contract in question have been terminated. The remedy available to the petitioner, the proper remedy available to the petitioner would be by way of arbitration.
Lordship.
And as such would not therefore press the instant petition. Just taking into account the above.
Lordship, if it can also be recorded that another contractor has already been appointed for.
No, that
My lord,
not
that one is
That is not
just before this
necessary.
terminated, my lord.
You know what is required to be done. Huh? Taking into account the above, the instant petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Well,
Lordship, have I been given the liberty to approach?
Huh?
Have I been given the liberty to approach?
However observed, before parting with the record, this court, however, observes that the withdrawal of the instant petition shall not prejudice the petitioner to avail remedies otherwise available.
Much obliged.
For admission from the supplementary course list, item number 24.
Worship, this matter was fixed for orders by order dated 4/04/2025. We were asked to reduce a judgment.
Oh, not this one. There's another one I delivered on the same day. Yes, here you have this case, the petitioners did not have 30 years. But here the petitioner has 30 years.
It's covered under 2015 office memorandum.
There was another judgment which I delivered, you know. Yes, so what is your stand?
Your Lordship, yes, it is covered under 2015 office memorandum, and basing on that, Your Lordship, the name of the petition has already been sent forward to the government for necessary approval, Your Lordship.
This is one for regularization.
Correct,
This was
correct.
sent when?
This was sent, Your Lordship, on 7th of March 2024, Your Lordship. And the name-
7th of March 24.
Yes, and the name of the petitioner, Your Lordship, can be seen as serial number 1, my lord.
Serial number 1.
Yes, on the next page, my lord.
Okay. So he completes on 29/11/2021.
30 years, yes, my lord.
Huh?
30 years, 29th of 11 to 2021.
The petitioner is completed.
29/11/2021.
Yes,
He
correct.
completes.
He completes.
So his right
Yes,
to be considered
yes,
accrues on the date on which he gets 30 years.
30 years, complete 30 years.
So we pass an order
Lordship,
to go ahead and finish the regularization process
Lordship,
within a period, preferably by 6 months.
correct.
And his date of regularization shall be on
Effective from
29/11/2021.
Lordship. Lordship,
Because his right
yes,
on the basis accrues on 29/11/2021.
yes, basing on the office memorandum, yes, he completes 30 years on this day.
So on that day, he is entitled to.
Yes, yes, yeah, he becomes
It
entitled,
may take some time
Yes.
because of logistic reasons. It may take some time,
Lordship,
but the date of his regularization would be on 29/11/2021.
Lordship, Lordship.
And all benefits he will get on the basis thereof. I think that is the best option.
Yes,
Because he's already getting the work, the skill. of
yes,
it.
yes, yes.
Everything he is getting.
Everything is good.
Only thing he is not, here is not being regularized.
Yes, yes, yes.
And this may have an impact only because he is retiring on 30/4/2025.
Correct, my lord.
So it may not be possible to finish off. so
Yes,
soon.
yes, yes,
I understand that problem.
Lordship.
So we therefore direct them to go ahead to go ahead, but only thing is it will be dated with effect from so and so. There is already a Supreme Court judgment.
Correct.
Yesterday, one matter, you were there.
No, I was not there.
You were there. You moved that application now for 6 more months.
Yes, that extension. Yes,
Yes, you were there. Na?
yes, extension.
6 more months.
Yes.
So there I passed that order. That I have given them 6 more months.
Gotcha.
Go ahead, because already there was a direction on 22/8/2024, if I remember correctly.
Yes.
And the council's argument was already 8 months have gone and another 6 months, it will be 1 year. I said, okay, you go ahead, do it within that period.
Lordship.
But it will be dated with effect from the date on which he is entitled to. I gave the date.
Lordship.
I think I gave the date on 6/10. 6/10/2020. 6/5/2020, I gave the date. So this order I pass in that manner.
Lordship.
Heard Mr. Miss
Jamir.
so and so, the learned counsel appearing on behalf of the petitioner, Mr. So and so appears on behalf of the respondent state. The petitioner, respondents, all the respondents. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not granting the benefit, in not regularizing the services of the petitioner in terms with the office memorandum dated 17/3/2015, although the petitioner duly is eligible as per the said office memorandum. First, the case of the petitioner next, in short, in brief, is that by an office order dated 29/11/1991, he was appointed as labor on fixed pay basis of rupees 450 per month under the establishment of the SDO bracket PWD Tonokyo, THONOKNYU with effect from 1/12/1991. Subsequently, by an order dated 17/11/1995, the petitioner was temporarily appointed as a work charge office peon.
1993, my lord.
95, they have.
The type copy, your lordship, they have mentioned 1993. The
Okay.
next page, my lord. On page 19.
17/11/1993. Where is the original?
Page 18, my lord.
Sorry. Okay. 17/11/1993, the petitioner was temporarily appointed as work charge office peon in the pay scale of in the pay scale, along with other allowances admissible. First, the petitioner continued to render his service and still is in service. First, in terms with that, what is that act? Nagaland Employment?
Work charge and casual employment.
There's another act, no? Nagaland Employment Act. 35 years or 60 years. What is that act?
Nagaland, retirement from Public Employment Act.
In terms with the Nagaland Retirement from Public Employment Act 2000, 1990?
90, I think it's 1999, your lordship, if I'm not wrong.
Just find it out, huh?
Yes, sir.
Yeah. The petitioner would be retiring on 34/9/2025.
Yes, yes, my lord. Yes.
Is it because of that act? 35 years?
Yes.
Retirement superannuation, 60 years.
Huh?
he will be attending 60 years.
No, it can't be. No. But then also it will come in because 60 years he'll be completing, na? Lekho. The petitioner thereupon continued to render his service. Pusto. As per as the as per the Nagaland Hey Act, as the petitioner would be attaining the age of would be the petitioner would superannuate on 30/4/2025. First, the case of the petitioner herein that in terms with the office memorandum dated 17/3/2015, the petitioner is entitled to the petitioner's services are entitled to be regularized. First, and regularized as the petitioner have attained and have completed 30 years of continuous service with scale pay on 29/11/2021.
Yes, my lord.
The petitioner's case, however, having not been considered, the petitioner has approached this court by filing the present petition. It is noticed that this court had issued notice. The respondents thereupon have filed their affidavit in opposition on 24/3/2025. In the said affidavit in opposition, it has been mentioned that the case of the petitioner is actively being considered by the respondent authorities, and in doing so, the name of the petitioner have already been sent to the government for regularizing the work charge service of the petitioner in terms with the office memorandum dated 17/3/2015 by the letter dated 7/3/2024. Paragraph number 8 of the said affidavit being relevant is reproduced hereunder. In addition to that, in paragraph number 11 of the said affidavit, it has also been mentioned that in order to regularize the work charge services of the petitioner, the conditions which are provided in the office memorandum dated 17/3/2015 are to be first fulfilled. And in doing so, some considerable amount of time are being consumed for the fact that such regularization have to undergo a lengthy process, and therefore without complying to the conditions prescribed in the office memorandum in order to regularize the work charge services of the petitioner, it cannot be said have to undergo a lengthy process. Full stop. This court have also perused Annexure A to the said office memorandum, to the said affidavit, which is the communication issued by the engineer in charge NPWD to the commissioner in secretary for dated 7th of March 2024, wherein the names of the 5th phase of work charge employee were resubmitted. To the said document, to the said communication dated 7th of March 2024, a list is enclosed wherein it is seen that the name of the petitioner appears at serial number 1. It is further seen from the said list that the petitioner's date of entry in the service is 29/11/1991. The petitioner would complete 30 years of service on 29/11/2021, and the petitioner would superannuate on 30/4/2025. It is further seen that upon regularization, certain additional benefits, financial benefits would be payable to the petitioner. As would be apparent from the list enclosed. First, this court, upon perusal of the pleadings, have also taken note of the respective submissions made by the learned counsels appearing on behalf of the parties, and First, for the purpose of deciding the instant dispute, this court finds it relevant to take note of the office memorandum dated 17/3/2015. From a perusal of the said office memorandum, it is seen that the said office memorandum relates to the scheme for regularization and absorption of work charge and casual employees and the revision of pay wages, public wages. It is further seen from clause 1, Roman 1, that all existing work charge and casual employees of the various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of conditions as indicated therein. Full stop. The conditions which have been stipulated from A to H have no relevance in so are in respect to actions to be taken by the respondent authorities, respondent departments. As the same, under no circumstances, and the employee has no say, and it is not within the employee to comply with the said conditions. The only requirement as per clause 1(1) is that the person concerned employee has to have completed 30 years or more continuous service as on 1/1/2015 and on scale pay. Taking the case of the petitioner would come under clause 1 Roman 2, in as much as the petitioner do not complete 30 years as on 1/1/2015, but rather would complete only on 29/11/2021. First, taking into account the above, clause 1 Roman 2 is reproduced hereunder. First, it would be seen that from a perusal of the above quoted clause, that those work charge and casual employees in scale pay who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization would be taken up subsequently in 2 batches on the 1st July and on 1st of January every year. It is also seen that the procedure and terms will have to be same as laid down in the office memorandum. Let me go put the proper one. This court further takes note of clause 3 of the said office memorandum, which also stipulates that there are various requirements to be carried out by the respondent authorities, which would also include the concurrence of the finance department as well as the cabinet approval. First, taking into account that the petitioner completes 30 years of service as on 29/11/2021 and was on scale of pay, the petitioner's right to be the services of the petitioners, the petitioner's right to be regularized would arise only on 29/11/2021. Accordingly, this court further takes note of that the respondents are actively taking steps for regularization of the services of the petitioner and taking into account clause 3 of the office memorandum dated 17/3/2015, it would require some more time. Accordingly, this court disposes of the instant writ petition with the following observations and directions. Number 1, the petitioner case for regularization number 1, that as the petitioner had already completed 30 years on 29/11/2021, the case of the petitioner be considered in terms with the office memorandum dated 17/3/2015 at the earliest and preferably within 6 months from the date a certified copy is served upon the respondent number
2 and 3, Your Lordship.
2 and 3. 2 and 3 now. 1 and 3. 1 and 3.
1 and 3, my lord, yes.
1 and 3.
Lordship,
No, 1
even-
and
even-
4.
No, even 2 will be required, Your Lordship, because approval of the PNR also is required as per the office memorandum.
1, 2 and 3.
Lordship.
1, 2 and 3. Full stop. This court further takes note of that as the right of the petitioner to be services to be regularized arises on completion of 30 years, which would be on 29/11/2021, the regularization so made to the petitioner, the regularization of the services so made to the petitioner be made giving effect from 29/11/2021. First, next. The petitioner, on the basis of such regularization, be granted such benefits as permissible under law.
Lordship. I'm deeply obliged, my lord.
That's a wrong judgment. Take it. This is a case of dismissal.
For motion from the supplementary cost list, item number 26, bail application 2 of 2025.
Yes, where is the FIR?
My lord, your lordship will kindly find the FIR. 52. My lord, type copy is at page 53. May I read?
Page?
53. May I read, my lord?
Yes.
ID undersigned would like to inform your authority that there was an untoward incident on 18/5/2024 at Fulbari bus stand, taxi stand opposite to Oking Hospital at around 4:40 p.m. The incident involving Mr. Kire and I pronounce it in your lordship.
Okay.
So of Kohima village, leading to hospitalization of my father at ICU Oking Hospital and subsequently succumbed to his injuries on 19/5/2024 at around 3:25 a.m. During the incident, I was also assaulted by two aforementioned persons. I therefore urge your authority to kindly look into the matter for investigation and necessary action. Yours faithfully, so and so.
Yeah.
Now, in pursuance to this FIR, my lord, the North PS registered the case under section
302.
And 352, 323, 325, 302, Reg 34 of IPC as not PS case number 0045 of 2024. Now, my lord will kindly see, I was arrested on 19th
Of
the 19th of May
24.
24. 9th of May 24. My lord will kindly see two interesting developments. The lordship will find that there is an order of the Honorable CJM, Kohima, at that annexure P7, 25/2004, page 63.
Yes.
The lordship will see that the order is in one line, received FIR lost by so and so Sandbag CR. Now, I was arrested on 19/5/2024, but I was not produced before the CGM, Kohima. The order speaks itself. What had they did was that they took me to, without the transit remand, they took me to Wokha, Judicial Magistrate, JMFC First Class. There they took custody of 15 days, judicial custody. The ground they are saying there.
Judicial or police?
Judicial. So what I'm trying to impress is that when you register an FIR under the concerned jurisdiction, that is the CGM Kohima, because not PS falls under the CGM Kohima. So the CGM Kohima, before taking the FIR on record, should have asked, where are the two accused persons? Where did you make an arrest? Say yes. Where are those two persons? If you could not.
He was arrested by whom?
Kohima police. Kindly come to page 3. P3, page 56.
Page?
Page 56, page 3, annexure P3. The lordship will find this arrest, it is typed as arrest stroke court surrender form. My lord.
Huh?
The lordship is there, page 56.
What is this Okha is?
Your lordship, that is, I will take your lordship.
Why it has been taken to Okha?
I don't know.
No, wait, the production to the VC as to the payslip situated in production, accused so and so, arrested and produced before me in connection with the accommodation case. I know the case is paid for production of the year before me.
Okay, then, now what happened, your lordship? They try to justify in the forwarding, in the order of the landed JMFC, saying that safe custody of the accused persons. But the question is that, how can you shift a person to a other jurisdiction, that is other state, other district, without the order of a court under 167? There has to be a transit remand. Now that is not there. Now my lord will kindly come to the arrest come surrender form. Annex P3, page 56.
Page 56.
Page 56. Your lordship will find particulars of the arrested person where I named my lord. Now, at serial number 8, serial number 8, the arrested person, after being informed of the grounds of arrest and his legal rights, was duly taken into custody on 19/5/24 at 15:40 hours at North PS jurisdiction. Now, there is no mention of grounds of arrest. Now, coming down, your lordship.
Yes, no, it is there, na? List of checklist of the area, reasons necessitating the arrest, tick mark, which is there.
Your lordship, I will come to that. I will come to that. I will come to that. Yes, your lordship, at page 58, which your lordship is referring, reason necessitated the arrest. Now, reason is in general to prevent the accused person from committing any further crime. But the grounds of arrest have to be particular to the particular person. This has been explained in Parveen Purkasta's case, my lord, which I will take your lordship's kind attention subsequently. Now, kindly come to page 56 again, my lord. Page 56.
Yes.
My lord is there? The arrested person was cautioned to keep himself or herself covered for purpose of identification. Information given to Sri Nifisuto, relation uncle, my lord. Now this, they are doing it under section 58 of the CRPC, 1973. But that itself does not safeguard. Thing is that the grounds of arrest were not given to the uncle also. Now I will take your lordship to kindly to the authorities. This is the background.
Okay, then what did you do immediately thereafter?
Pardon?
Because he was arrested on 19/5.
My lord.
25, he was there in Wokar.
My lord.
What did you do thereafter? What were you doing all this while? We are in 2025.
My lord.
What were you doing immediately?
We did not file the bail application. We did not file the bail application.
Why?
Because, my lord, I believe, to be very, let me be very frank and honest to this court. When the hearing was done in the trial court, the state public prosecutor showed a news article to the concerned court saying that a particular organization is making demands that not to release these persons on bail. Okay. Second thing is that, as I have been instructed by my clients, is that environment was very hostile So that is the reason why they could not file application and all. And I was very surprised, Your Lordship. I was very surprised that when the Pankaj Bansal judgment came, that was in context of PMLA, my lord. They're saying that the grounds of arrest has to be given to the accused persons henceforth. Now that issue, again, as it was hesitated in Unlawful Activities Prevention Act in Parvi Purgasta. What the Honorable Supreme Court said that in Parvi Purgasta,
I understand all these things.
My lord.
What were you doing immediately thereafter?
my lord, we did not file the bail application.
Why? You could have filed it here. Why haven't you filed it?
Well, that some other councils were engaged. I don't know when I came to.
Understood. All these things are understood. Therefore, the question is, he is now put inside under 302.
My lord.
Now you are challenging on the counsel of a ground of arrest.
My lord.
Now the question is whether his requirement is necessary now. Because you didn't do anything at that point of time.
No, my lord, that issue.
I never understood immediately. It has left 2 months, 3 months. Only this is a year.
But can your
But
lordship,
can this court on that basis grant you a year?
your lordship, I will apprise this in this particular way.
You have to look into the CD. Read the CD Friday.
My lord,
Right.
Yes, my lord.
I would just like to observe one thing.
Right?
Can a fundamental right be waived? No, because that is what in Vihan Kumar's case it has said.
Understood, whatever may be.
My lord.
We are concerned out here that this is a case under 302, a person has been booked. The ground of arrest which was there, why he was produced in Voka has also been clearly stated by the judicial authority. He did not file a revision thereafter. No steps were taken at all this while. Now, this seems to be the first bail application which was moved before the trial court.
My
Sessions
lord.
court.
My lord,
Where is that order?
your lordship will find the impugned order next year P1.
It's not an impugned order.
Pardon, my lord?
This can't be an impugned order.
No, this is not, I'm not challenging this is an impugned order, my lord. The order of the London Sessions Court is of 4/4/2025, annexure P1. What the London trial court did was that
So the trial has begun.
trial is begun.
Okay,
No.
then we have to call for the scan copy of the trial.
My lord,
Yes, my lord.
Scan copy of the trial.
Yes, my lord.
your lordship will appreciate two things before your lordship take a call. First thing was that though the grounds of arrest was not mentioned in the FIR, second thing was that the order passed by the
No, you never assailed those. You never took up any step for that. You were very happy. You wanted to be inside in Voka. That is what it appears.
No, I am raising it now. Under which law can you stick me?
No. Now the trial is going
So
on.
what, my lord?
So
Supreme
what
Court has
is-
said. Supreme Court has
Go to
said.
Supreme Court.
No, I will take your lordship.
No. I'm very clear. Without seeing the scan copy of this, I'm not.
Okay, Lordship will call for the scan copy. Lordship will call for the scan copy. But I am saying the Supreme Court has said in Bhavipur Kasta, even in Thokson's case, that even the charges have been filed, charge sheet trial is going on. Still, when the inception is wrong, you have to release him. That is what I have specifically quoted in my petition. So, your Lordship, one for example, there are many indigent persons who doesn't know ABC of the law. Now, can we say to that person, you did not raise for so many years, so now you cannot tell? Can it be the argument? No. Now, for example, many mistakes we as a council do. We as a council do. So, for the mistakes of the council, whether the person has to suffer? No. And my lord will appreciate the intention of filing the 227 petition, your lordship, was not only for myself. As an officer of the court, I wanted to bring to this knowledge of this honorable court to look how it has been going on. Let this court exercise the jurisdiction under 227 and issue guidelines, direction that it has to be done. That is what PepsiCo judgment said. If your lordship will kindly find this judgment, your lordship, just for a moment. Thank you.
Washing of a criminal.
No, yes, your lordship will find. Kindly come to para 21. Kindly come to para 21.
Yes.
The questions which arise for considerations are, if in the circumstance of the case, the appellants rightly approach the High Court under Article 226 and 227 of the Constitution, and if so, was the High Court justified in refusing to grant any relief to the appellants because of the view which it took of the law and the facts of the case? We have thus to examine the power of the High Court under Article 226 and 227 of the Constitution and Section 482 of the Code. Now, para 22 it goes. Kindly come to para 22 where it starts. Under Article 227, the power of superintendence by the High Court is not only an administrative nature but is also judicial nature. This article confers vast powers on the High Court to prevent the abuse of the process of law by the inferior courts and to see the stream of administration of justice remains clean and pure. The power conferred on the High Court under Article 226 and 227 of the Constitution and under Section 482 of the Code.
Mr. Bulama, only don't show me these type of judgments. Show me those judgments which has a relevance to the case.
My lord, your lordship will kindly come to beyond judgment.
Kindly don't show.
Beyond judgment, your lordship.
Which is relevant to the issue, tell me.
Beyond judgment.
Say that if it is wrong.
Para 21. The issue was, kindly come to the beyond judgment. Your lordship will find at para 1. Amongst other issues, the main issue canvassed by the appellant in this appeal is the violation of the appellant's rights under Article 22(1) of the Constitution of India, as the appellant was not informed of the grounds for his arrest. Para 21 conclusions. The requirement of informing a person arrested or grounds of arrest is a mandatory requirement of Article 22(1). C. When arrested, there is a non-compliance with the requirements.
No, show me that one.
Where?
That judgment to that effect wherein it says if it goes to the root of the cause.
Your lordship, I'm reading it. It comes here only.
Where? Para?
Your lordship will kindly see D. Non-compliance with Article 22(1) with all of the will be a violation of the fundamental rights of the accused granted by the said article. Moreover, it will amount to a violation of the rights to personal liberty granted by Article 21 of the Constitution. Therefore, non-compliance with the requirements of Article 22(1) vitiate the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Needless to add that it will not vitiate the investigation, charge, speech, seat, and trial. But at the same time, filing of charge will not validate a breach of Constitution mandate under Article 22(1). F. E. When an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) and other mandatory safeguard has been made. And if a violation of Article 22(1) is established,
it is a duty of the court to forthwith order the release of the accused. That will be a ground to grant bail even if statutory restriction on the grant of bail exists. This statutory restriction do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is established. My lord will appreciate this. The what is happening in
Mr. Suppose you do one thing. We have it on Thursday. You just find out this document, page 58.
my lord,
Page 58. I don't require anything else. Page 58. Whether this is the ground of arrest.
My lord, let the matter be come up on Friday, my lord.
No.
Friday, because
I would have had it if it was in Gauhati. I'm not asking you for anything else. Only find out this document. Because this cannot be said to be a ground of arrest. To prevent the accused from committing any further crime. If this is the document on which the ground of arrest was there, this court has to pass appropriate orders holding the arrest to be legal. This one. But if other grounds or any other reason some have been mentioned, this seems to be a bit not in consonance with law. Only this document. I don't want anything. Ask the police officer, whoever has done it. This is from where?
not PS, my lord.
Oh, yeah, nearby.
Nearby. Yes.
So ask him as to whether this is the ground of arrest here. And the case is at Wokha.
No. Case is pending before the United Sessions Court, Kohima.
Kohima?
Yes.
Kohima.
Yes, Kohima.
so my lord, let the matter come up on Friday, my lord. I'll bring the scanned copy of the CD.
Mr. Counsel, kindly, as I said, PP's role is to be unbiased, to be either of parties. Now, you are not actually a representative of the state. You are a representative of law. If you want to be named as PP. So we are not concerned. You just find out. If you have any difficulties, ask any other PP who can very well take appropriate steps. Or I can very well ask the session judge also. Session judge here.
Yes, my lord.
So ask the session judge to say as to whether this page 58 is the ground of
No,
arrest.
she has recorded, my lord.
That has not been recorded.
Very different way.
Where?
The lordship way. Annex of P1,
Where?
para 16, page 53.
Sir, I have read it. That is why I'm saying here this aspect is not apparent.
No, that's what I'm saying.
That is why I want whether this page 58 is the document or not.
Your lordship, then why don't your lordship, my humble submission, why doesn't your lordship directly IO the case to come with the CD?
CD can't be there
Yes,
now.
now
It's
CD.
in trial.
Trial.
Mr. Buragwal, kindly appreciate it is in trial stage. So that's this has already
Session
been
court.
charge sheet has already been submitted.
My lord.
So therefore the IO has no business out there. Only thing is as to whether this particular document was the document which was issued. That is what I want you to verify.
Yes.
That's the only document. Okay?
Okay.
And okay. The heard Mr. S. Buragoy, the learned counsel appearing, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent state. The petitioner herein, the instant petition has been filed under section 483 of the BNSS 2023, seeking bail primarily on the ground of violation to section 50 and 50 and
50A,
huh?
50
and
50A of CRPC
50.
50, madam. And Article 21 and 22(1) of the Constitution.
50, section 50 of the Code of Criminal Procedure 1973, on the ground that the ground of arrest which was provided to the arrested person was
No grounds of arrest was provided, my lord.
arrested person. Had no relation whatsoever. On the ground that the ground of arrest grounds of arrest so provided to the arrested person did not on the ground that from the ground of arrest so provided to the grounds of arrest so provided to the arrested person, nothing could be discerned and thereby the very object of the constitutional safeguard in section 50 of the CRPC read with Article 22(1) was violated, of the Constitution was violated. This court have also taken note of the recent judgment of the Supreme Court in the case of Vihan Kumar versus State of Haryana and others, reported in 2025 SCC Online SC 269. Taking into account above, this court fixes this matter on
Thursday.
What is the date? 10. 10/4/2025. The learned public prosecutor is directed to ascertain from the investigating officer who had submitted the charge sheet as to whether the ground of arrest
Is mentioned in the arrest memo, my lord, because your lordship is referring to reason for arrest. Kindly see the page. It is not grounds of arrest, my lord. Serial number 6, reason necessitating the arrest. Take whichever is. So there is only reason for arrest, not even a whisper of grounds of arrest.
as to whether page number 58 and the grounds of arrest as mentioned at page number 58 of the petition, bail petition, was the said document so provided to the arrested person. This court further directs the learned court of the Principal District and Session Judge Kohima to before whom the trial is proceeding. Trial in connection with
GR case number 83.
of the 2024 is proceeding to place to send the scan copy of the
Arrest memo is required, madam.
scan copy of the first information report, comma, the arrest obliques court surrender form, and
Any order of transit remand, madam. Though she has accepted, there is no such order.
the first information report, the arrest oblique court surrender form. Because that document is attached, no?
Pardon, madam?
That document is attached with this, no?
Yes.
Sorry. Along with the documents enclosed those documents, and along with the documents enclosed. Before this court. And to this court. Court and ensuring that the same is received by the registry of this court. The same can be placed before this court on 10/4/2025.
In seal cover, madam?
Why seal cover, scan code?
My lord, your lordship, that 227 matter is there, that will be, let it be posted on 10th only.
On 10th, yeah, Pustap. A copy of this order be the Pustap. The copy of the registry is further directed to immediately send the copy of this order to the learned district and session judge
Kohima.
Learned this principal district and session judge Kohima, two special messengers during the course of the day for due compliance.
For orders, item number 10 and 11.
Copy the lordship.
Service not complete.
Not complete. Lordship.
Service being not complete. Who is 2 and 3?
Lordship, the owner and the driver, lordship.
You are the insurance company.
Lordship. Period.
What are you challenging?
Lordship, the impugned order, how it is passed, it is totally perverse, lordship.
Why?
Lordship, the legal grounds which are involved in this appeal, lordship, it has not been followed.
Huh?
No, it has not been followed while passing the impugned order, lordship.
Why?
Lordship, number one, the claimant, the claimant, while traveling, the facts of the case is that while traveling to his home, he sustained injuries by one vehicle, and out of that he sustained injuries, and the disability certificate he produced is by not from a competent medical board, although the law says that it has to be from a medical board, but it is from a psychiatrist. The learned MACT has
So
overlooked.
are you denying to the fact
Lordship,
there was no insurance?
no,
Are you denying to the fact that that if the accident was otherwise proper,
Lordship,
just for example, if the
Lordship.
accident is proper,
Lordship.
that it is the owner or the driver who has to pay, not you?
No.
So there was an insurance policy.
Lordship.
So why do we need the owner and the driver? We dispense with them.
Lord, may it please your lordship, prior,
Why do you need the owner and driver? Because the insurance company is going to indemnify
Lordship.
the owner.
Lordship.
There is a valid insurance policy.
Lordship.
Now, if the accident has happened or not, it is a question, is a different aspect.
Lordship.
Evidence is over.
Lordship.
The owner and driver never appeared before the trial court.
Lordship.
They did not participate or file written statement, did they?
No, no, owner and the driver, they appeared, Lordship.
And what did they do? They admitted what they have done. That is the normal norm.
Lordship, Lordship.
They say that the accident they have done, but we have an insurance and this is the insurance was valid.
Yes, they will.
That is the stand.
Yes.
So you don't require that. Now the question is as to whether this imposition settling of this liability upon the insurance company of this quantum was proper or not.
Lordship.
That's the question. So why do we need the owner and driver? Unless we strike off their names, proceed with the appeal.
lordship, otherwise also before going into the merit of the case, lordship, IA 54 has to be considered, lordship.
What is that I?
That is for condonation of delay, lordship.
So we strike off this and condone the delay.
Lordship.
How much?
Lordship, no, they are saying that it's 487 days delay, lordship.
For
487 days delay.
what's the
However,
ground?
no, lordship. The ground is on
At
their
para,
petition,
6,
para
Lordship.
6, lordship.
Huh?
Para 6, Lordship.
Para 6.
Lordship.
Lordship, the judgment and award was passed on 12/9/2022, lordship. Only after when an execution case was filed against the insured, they preferred the appeal, lordship. Now they are praying for 487 days delay. However, from the date of the judgment and order until the filing, it's 575 days delay, lordship. And
So we
then
dismiss it on that ground.
it has not been properly explained.
How many times? The last time also when I came, I dismissed 2-3 appeals.
Lordship, subject to correction, Lordship, it is 487 days.
487 days or not. The grounds which is there in paragraph number 7 is not good. Not good.
Lordship, dismissal on that, Lordship, it will be purely Lordship, technical Lordship. Otherwise, there are merits, the case, Lordship.
Huh?
The grounds which I have taken, Lordship. There are merits, Lordship. Dismissal on the ground.
If there are no merit, why should I look into the Supreme
Lordship.
Court has been clear on categorical terms
Lordship,
that this can't be the reason why it should be done.
lordship, I have prepared a small gist, lordship. May I, lordship?
If I was the judge, I would not have issued notice only. Did I issue notice? I don't issue this type of notice also.
No, your Lordship was not there.
Huh?
Your Lordship was not there.
And you have suffered 2-3 orders also in my hands.
Lordship may consider my grounds, Lordship.
Let's see. Have you paid the money?
No, no.
Not.
Then why? You are not proceeding. This has not yet been done. Then
The execution case is pending, lordship,
Huh?
until they file this appeal, lordship.
Lordship, the disability certificate
this
which
can't
they
be,
have
Lordship.
produced, Lordship.
I'm not going to this, you know. Your ground is not good. You file objection?
No,
No.
no, Lordship. No.
Huh?
The gist, only gist. Now I'm filing the gist.
No, you have not filed objection yet.
No.
Why? You file it by Thursday. I'm taking up on Friday and dismiss. File it. Thursday?
Thursday. Lordship, tomorrow I have a matter.
Huh?
Exam.
No other court will do that, except me. And I have passed 2-3 judgments also like this against him. He is the person who has suffered. And all these, well, the ground which he has mentioned, I have looked into these type of grounds earlier and dismissed. And recent judgment of Justice Pardiwala also has there. Where you have to not also explain there, you are also to explain why within that 90 days you could not file.
It's there, Lordship.
So what to do? Chalo. This court had inquired with the learned counsel appearing on behalf of the applicant as to whether the applicant contests and whether the applicant herein denies the existence and denies the liability to pay the compensation on the ground of no insurance policy or the terms of the insurance policy being violated. Mr. V. Devnath submits that the grounds of objection taken in the accompanying memo of appeal do not stipulate such grounds. Taking into account of the above, the presence of the respondent number 2 and 3 is not required in the instant application. Accordingly, the names of the respondent number 2 and 3 are struck off. The registry shall, on the basis of the instant order, carry out necessary correction in the cost title as well as also update the same in the CIS. List the matter again on Friday for consideration of the application for condonation of
For hearing, item number 12 to 15.
Yeah, Lordships, I've been going through the file, but Lordship, my sincere apologies, Lordships. I'm not in a clear state of mind to assist this honorable court, Lordship, this moment, Lordship, in the limited time. Maybe gracious not to grant us time, Lord.
Yes.
My senior is also in this also, Lordship.
See? You're supposed to get a good order, your senior is not there. So when do you want it?
Lordship,
we adjourn this matter sine die and to be listed after 2 years.
Lordship, maybe gracious not. Lordship, after 2 weeks, Lordship. Kindly, Lordship.
Now, the present batch of appeals present batch of appeals is in connection with one judgment, na? Same
Lordship.
judgment.
Lordship. Common judgment.
Is in connection with the judgment dated 23/1/2020 passed in how many MSC cases? 3.
For lordship.
Passed in 4. The present batch of appeals have been filed in the year 2021 in connection with a judgment delivered in the year 2020. It is seen that the appellants herein have been seeking time and the respondents, who are the claimants, are also not interested to further pursue the appeal, to contest the appeals. The manner in which these 4 appeals have been conducted is portrays a very sorry picture, depicts a very sorry picture to the plight of the claimants who have not been able to receive the compensation in view of the pendency of the appeals, and the counsels for both the claimants as well as the appellants are not taking appropriate steps to bring the dispute to a logical and early to bring the dispute to an early resolution. Considering the above, let these appeals be listed again in the month of October 2025. 1, 2 months, 3 months, 4 months, 5 months, 6 months. November, first week of November 2025.
For hearing, item number 17.
What is this?
Lordship, here the petitioner has challenged the criminal complaint that I filed before the Learned Chief Judicial Magistrate.
You are the petitioner?
Lordship, the petitioner,
Lordship.
I believe, is in counsel.
Yes, Lordship,
Yes,
I am from petitioner side.
tell me.
Lordship, Lordship, I have challenged the order dated 28/3/2022, 19/5/2022, and 6/6/2022, passed by CDM Kohima, and summoned the applicant under sections 403, 406, 417, 418, 420, and 506 of IPC. The
Yes.
impugned order is on page 72. Kindly have the order, Lord. Page
Why
70,
you are deleting?
annexure number 2.
Annexure,
Annexure number 2, second.
page,
Annexure number 2, page 70, 70,
70.
70 and 72.
Yes.
Lordship, this order was challenged before the Honorable Court, and the Honorable Court passed order on 9/7/2022, staying the proceeding laying before CGM Kohima.
Then,
Then thereafter, Lordship, pleadings were completed and the matter is ready for the hearing. The fact of the case is that complainant and opposite party number 2 are real brothers. And opposite party number 2 is elder brother of the applicant. And on his initiation, he started business
wait,
in partnership. Lordship.
Mr. Counsel, just wait. What is
Lordship.
this? This person is in Uttar Pradesh.
Lordship.
What is
Lordship.
202 has gone for a 6. How could you dare do this?
I beg your pardon, my lord.
Section 202 makes it clear that when a person is outside the jurisdiction of the court, it is required for him to make an inquiry. Where's the inquiry?
Lordship.
How is it to do these type of things?
Lordship, that is an issue that has not been raised in the criminal petition. For what is
Not
worth.
really required. I thought the lawyer out here must have thought that the judge knows it. So he did not raise it. But without 202 compliance, how is it possible? Isn't it mandatory 2021? There are many judgments which have been held to be mandatory.
Initially, I had approached the police station. Lordship, this is not a case where I, as a brother, as an elder brother, to be particular, I have approached the police station over the smallest squabble between siblings, Lordship. Here,
You
is
are
a case-
brothers?
Lordship, yes.
Then you are fighting?
Yeah, Lordship, unfortunately, that has happened.
You stay in Kohima
Yes, Lordship.
and he stays in Uttar Pradesh.
Lordship, initially, he, at some point of time, he came and resided with me. Yes, but now he's shifted there after we came to an agreement that we would enter into some kind of a business venture. And as per the agreement, it was his duty to reside in Balia, which is in Uttar Pradesh. And from there, he was supposed to discharge his part of the duty, his part of the agreement in conducting business. However, this is also not a case where the agreement between them, he had duly executed his part, and because there was a failure of the business, I have abused the process and initiated criminal law. But here is a case where he has dishonestly and deliberately omitted to do his part of the agreement, and therefore, Lordship, amongst others, it is a clear case of criminal breach of trust. Lordship.
No, that cannot be a criminal. He did not do it. It's a criminal breach of that is a criminal contract. It will be a breach of the agreement.
Lordship,
It's a civil dispute.
my case is clearly covered under the illustrations also. Given the opportunity, I'll satisfy my lord. And when I had been so patient being an elder brother, but ultimately when I confronted him, I was intimidated with physical injury and death. And therefore, I have invoked the provision of criminal intimidation as well, Lordship.
So you filed an FIR.
Yes, Lordship. I had filed an FIR.
What happened to the FIR?
The FIR,
Because the criminal intimidation normally is done through FIR.
Lordship.
What have you done?
Yes, I believe though it was not registered, so far as my knowledge is concerned, I am not aware if an FIR was registered, which it was duty bound to do so, but they have not done so. But a communication was made to the accused person here. And in reply, he had made a reply to which has been enclosed as part of the criminal petition. And thereafter, it is not in my knowledge as to why he had not taken, my lord.
We set aside this order and remand it back to the court to apply 202 and then the issue process 18 feet.
Very well, my lord.
That is the only order.
Lordship, however, coming to one technicality, the learned counsel for the petitioner, he has, if my lord were to examine the petition, he has produced a whole new set of evidence with counter allegation. He has introduced another ledger. My lord knows that
I'm not going to
in a criminal petition, the court is not to go into evidence, my lord.
I'm not going to look into all those
My
things.
lord, my lord.
You may think whatever may be, but the question what I'm thinking, that as there is no compliance to 202,
Lordship.
We interfere with the order of
Lordship.
issuance of process
Very well.
and direct the authority of the court to take appropriate steps in terms with by following the mandate of 202.
Very well, Lordship.
And thereupon nothing remains.
Lordship.
Yes, what do you say?
Yes, Lordship, I'm agree.
Urge Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so appears on behalf of the respondent. First, the petitioner herein have invoked the inherent jurisdiction of this court under section 482, read with the revisional powers under section 397 and 401 of the Code of Criminal Procedure 1973, seeking quashing of the complaint case being CR case number 02/2022, as well as the various orders being passed by the Court of the Chief Judicial Magistrate, Kohima, Nagaland, in connection with criminal complaint number 02/2022. First, this court, taking into account the order which this court proposes to pass, it would not be proposes to pass, this court is of the opinion that further detailing into the facts would prejudice both the parties, and as such, on the limited aspect, this court, only on a limited aspect, the facts leading to the filing of the instant proceedings have been narrated infra. First, where's the complaint? The respondent number 2 herein,
My lord.
Yes.
herein, had filed a criminal complaint before the court of the Judicial Magistrate First Class, Kohima.
Lordship, the Chief Judicial Magistrate.
Chief Judicial Magistrate First Class, Kohima, against the petitioner herein, alleging inter alia that the petitioner herein had committed offense under 406, 417, 418, 420, as well as 503 of the Indian Penal Code.
Lordship, 403 also.
403. 403 also. I got worried. Upon filing of the said complaint, the learned, which was registered as criminal complaint number 02/2022, the learned Chief Judicial Magistrate Kohima forthwith issued process upon the petitioner herein without taking recourse to section 202 (1) of the Code of Criminal Procedure 1973, which categorically mandates that when an accused is outside the resides outside the territorial jurisdiction of the court, a mandatory inquiry is required to be carried out. First, taking into account the provisions, taking into account that the petitioner herein admittedly resides in the state of Uttar Pradesh, which was outside the jurisdiction of the learned Chief Judicial Magistrate. It was incumbent upon the learned Chief Judicial Magistrate to take resort to Section 2021 before issuance of process. Considering the above, this court therefore interferes. The Chief Judicial learned Chief Judicial Magistrate, having not taken into consideration the provisions of Section 202 before issuance of the process, clearly shows complete non-application of mind. Accordingly, the order dated 28/3/2022, passed in criminal complaint number 02/2022 by the Court of the Learned Court of the Chief Judicial Magistrate, Kohima, Nagaland, is accordingly set aside and quashed. This court, however, in the facts of the instant case, is not dealing with the challenge to the said complaint, to the complaint filed by the respondent number 2, as the said aspect would only arise if the learned Chief Judicial Magistrate, after following the due process, after following the mandate of the provisions of 202, takes appropriate steps for issuance of process. Accordingly, the instant proceeding stands disposed of, thereby setting aside the order dated 28/3/2022, passed in criminal complaint case number 2/22. The petitioner herein, the respondent number 2 herein, shall approach the learned court below, learned Chief Judicial Magistrate Kohima, with a certified copy of the instant order, and on the basis thereof, the learned Chief Judicial Magistrate, by taking into account the relevant provisions of law, decide as to whether a case for issuance of process have been made out or not. Next, this court, however, before parting, finds it relevant to observe that this court is not deciding in the instant proceedings as to whether a case is made out on the basis of a reading of the complaint for the reasons aforesaid. However, it is observed that in the circumstance any process is issued against the petitioner by the Chief Judicial Magistrate, it shall not bar the petitioner to approach challenging the complaint petition. I gave you the liberty if a process is being issued to against Shelley and Shia.
For hearing, item number 18.
I am obliged, Lordship. Deeply
I have not, Mr. Upadhyay, I have
Lordship.
not, as I have only set aside, I have given a liberty that in the circumstance at a later stage, if again process is being issued against you, you are at liberty to challenge the complaint here.
Lordship, I have to come there again. But if PM was ordered summon the applicant. Basically, this matter is based purely civil nature. All right, Lordship, all right. I am satisfied by your order, Lordship.
Because otherwise, why should I take it? If the process has been, tomorrow the court
Well,
does not issue
yes,
process, then matter.
Lordship, yes, Lordship. I am satisfied by your order. You are right on the way, Lordship. I am deeply obliged.
Okay, item number?
Deeply obliged.
18.
Yes, Mr. Vicky. You are for the?
I'm for the appellant, Lordship.
Then. What is this?
Lordship, before your Lordship proceed with the file, Lordship, I would like to pray for indulgence, Lordship.
What happened?
Lordship, actually, I was not in Dimapur for a week. I was in Delhi for my mother's treatment, and I had reached only last midnight. I had already taken the consent of the other side, Lordship. I'm not fully prepared. If your Lordship may accommodate at least a day or two. There are two hearing matters pending. 18 and
Injury?
Lordship, both are injury matters.
Huh?
Injury matter, Lordship.
8 lakhs.
Lordship.
What happened?
Lordship, it is.
Yes, Mr. Counsel. What happened to your counsel client?
She was hit by.
Now, what is the injury? What injury is this?
Your Lordship, the impugned judgment is.
Why in Nagaland everything is being done?
That is what, Lordship. She's as per the service record, Lordship. She happens to be the warden of Gauhati Wildlife, Lordship. But in the claim petition, it has been.
So what injury is that question?
Lordship.
Major surgery in the right side of my leg. I was therefore referred. What happened?
She was hit by a vehicle at Gauhati, Lordship, near Chanmari area. Then.
And why she has come all the way to Nagaland? Huh? What is this? Accident happens out there. She resides where?
She resides at Mokokchung. That is yes,
Huh?
Your Lordship. She resides at Mokokchung.
She resides in Mokokchung.
Yes.
Then how did you appeal? Get notice of the appeal? You have to, it has been given here. Where is your claim petition? Chalo, I think you may have a case. Okay, at the request of the learned counsel appearing on behalf of the appellant, matters then adjourned to be listed when?
Lordship, on Friday, Lordship, because again I'll be leaving on Saturday to Delhi. She's admitted in the hospital. So again I'll be there for a week or 10 days, Lordship. Or if your
Not
Lordship-
Friday. Friday got lots of matters on there.
Lordship. Then after 18th, Lordship, because I'll be back on 18th or 19th of this month.
Registered again on 25th of April.
Lordship. Okay.
Yes.
My lord, one more hearing is there. Item number 25.
Item number?
25.
What was that?
Supplementary cost list.
The matter was listed yesterday.
Yes.
And your Lordship has passed over the matter for the day.
Which one?
Lordship, this is my conviction was only based on my.
We'll take it up tomorrow.
Huh?
Tomorrow, Lordship.
Tomorrow, I think, how many matters are there? Have you seen the list? Part two, I have a DB.
Yes,
Not
Lordship.
uploaded now. Cost list has not been uploaded, madam. First
Somebody
thing,
said I am sitting. Tomorrow, how many items are there, DB?
Lordship, I have seen that Lordship is sitting for division bench also, and then
For single bench, you have 2 matters. 2 matters of single
Huh?
bench. 2 matters of single bench.
Single bench. Then, huh? So you will list the matter tomorrow. Huh? We'll take it up. You mentioned this, I forgot, I was just thinking, what happened to that matter?
Lordship, since it's in the supplementary.
Because I
list,
don't
had
pick
to
up,
wait.
huh?
Since it's in the supplementary list, I had to wait, my lord, since there were.
No, you should have mentioned it about this. I actually, what happens, I never see my list anyway.
Yes,
And I also don't take away all the files. All
Yes.
files are here. I never carry anything, so I don't know. So this matter. Anyways, so after 4:45, it will not. I'll take it up tomorrow.
Okay.
like